Which one? No, 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 no. I have heard Mr. Arbor Pujari, Mr. P. Naik. Mr. P. Naik last time said that he's going to go through it and come back today. Nothing doing. Today is for orders. I'm dictating the judge.
Supplementary item 1 pertaining to it on our bench.
And Mr. Solia asked Mr. Arbor Pujari to be present, Madam. Yes.
Yes, sir. Yes. Oh, yeah. Oh, respondent has to file affidavit in reply. Affidavit in reply from the respondent. Respondent petitioner.
30th of August 2024, I have gone through it and your lordship was given opportunity to go through it. I found, my lord, that is in the group B officer. So that is not applicable in our case because our case pertains to group C officers, not officers, employees, non-gazetted. They are not gazetted officers. Now, 30th of August 2024, their release order was passed on 18 and 28. Your lordship recollect 18 and 28 September. Now, what I found, the government has come up with an office memorandum on 24th of September 2024, which pertains to Group C now. Now, this is not before this court because the district just cannot apply because that was not there at that relevant time. So it was after that. Now, in that, I will show it. In 24th of September 2025, that doesn't include that you have to get an approval or you have to get an approval from minister as Group B. It is the head of department, cadre controlling authority, you can apply. Absolutely no problem. The problem there is 9 years. 9 years. Again, the same thing you fall back on 30th of August 2024. But greatest respect, my lord, that 24th of September 2024 in our case will not apply. At that relevant time, it was not existing. That is number one. Now, in absence of any, then there is an office memorandum 1. 24/3, 2024, there is an office memorandum which is consolidated. 28/3, 2024, there is an office memorandum which is a consolidated office memorandum. Now, if you see that, well, there is no power has been given to whom it has to be applied. At least I have gone through it, your lordship will please go through it. But again, the provision of that 9 years is there. But if on the ground, if it is on the ground of spouse, then you can apply and that 6 years the provision is 6 years. But that is not the case. That is not applicable in the present case. Now what will apply?
Mr. Das, I'm not about it. What is your prayer? First, the revocation of the approval be set. Now, question is whether the district judge, who is actually in possession of the matter, not the one who was absent,
Yes.
Because the earlier was an big judge who was in the middle of the matter could have revoked it. That's the question.
Right.
Now, if the district judge has done as per the direction of the High Court, on the ground that there was no concurrence from the High Court as regards sending ministerial stuff comes under 235. That is the now as regards the disciplinary proceedings. Once if I don't interfere with the revocation, proceedings will go on with logical continuity. So why should I go into so much?
You want to respect lordship with great respect, my lord. That if on end of the day, my lord, that's what I told. I don't know in what manner.
And if
How
there
they-
is some gray area,
My lord, I think,
I'll crease out.
my lord, your lordship has to. My lord, what I'm saying. Now, what I find,
And I'll do it in your
no,
presence.
my lord, I find it will be, it's a gray area is there. And it will be difficult on the part with great
And
respect.
Mr. Das, you may get some benefit only one thing. If Mr. HK Das somehow jumps out here and supports that the High Court does not have the power, he makes it. Otherwise,
But again, my lord, apart from this, if you just leave for a moment, but what I find, my lord, the High Court's part 235 concurrence cannot be curtailed because of the rule of 2013, the rule which they have made, and the power which is, it is a rule of the High Court which made, and residuary power is given.
no,
My,
the rules are not of the High Court. These rules are made by the state on the recommendation of the High Court.
but recommend, sorry. In,
Unlike a 229
No,
rule,
I correct it, my lord. I correct it and say it is made by the state on the recommendation of the High Court. Now, if you look into it, recommendation of High Court, then, see, my lord, I am not on this case. Forget for a moment. What I am saying, same thing will again will go into Bakshi's case, the first case, because there the power which will applicable. Whether 235 will be applicable as a recollect or which will be applicable, that the CCS rule will be applicable. Then the Supreme Court said that it is a power under 235 where the High Court will apply concurrence. Now thereafter, Gujarat and the power is given. The source of power again will be given so far ministerial establishment is concerned. Now, if this is true, now if that day your lordship, as I recollect, that your lordship has said the power has been given, residuary power has been given. So his argument is limited to that residuary power. So then 235 goes. If I am not wrong, 235 goes. Because on the approval of recommendation of the High Court, that rule has been made. Recommendation was given by the High Court.
no.
Then
The
what happens?
residuary power which was given in terms with that particular rule was only in the context of what is your right to go on deputation. You say that by virtue of this residuary power, as any officer of the state government can go on deputation, I can also go.
No, yes. No, my lord.
Because otherwise the question was, you have put a specific, first you started your argument on that day on the question that I have gone on deputation, but there is nothing, there is no prescription what is to be done. So therefore, the district judge was justified in being the appointing authority to allow to go on deputation. That was your submission. Then I put the question to you.
Yes.
Where is the power of deputation to go?
Correct.
And if there is no power of deputation, why is the requirement of a
Right.
prescription?
Yes. My prescription was in context with my prescription.
Yes, no, Christina. Please, yes. Mr. Counsel, kindly mute yourself. Mr. Counsel, what's his name? I forgot. Mr. Tapin, kindly mute yourself, both of you. Yes.
Mute.
Yes.
Now, one I found, let him take time, I don't, because I have prepared. I
No,
just,
no, he's taking time is not
no,
necessary.
no, but what I found one thing, my lord, subject to what your lordship, how lordships react and deal with this issue. In absence of any office memorandum, district judge has done it, he has not applied correctly the office memorandum, it is respect of the B, group B, which is not applicable in the case, then when did this power, source of power, from where it can be traced? I found that the source of power can be traced under the fundamental rules. If your lordship looks into the fundamental rules and see section 5, chapter 5, please look into the
Yes,
fundamental.
fundamental rules.
Same, page 619, same negative.
Fundamental rules. Yes.
Appendix 5, section 5, madam. Appendix 5, section 5.
Appendix 5.
Yes. And section 5, there is appendix 5 as a section. Section 1, section 2, section 3.
Hey, kono, homor hoy.
No, not that. Swami's comprehension. It was assembly support. I don't. Yes. Swami's comprehension. Kindly look this. Take it. Page 619. 619. 6. Mark 619.
Yes.
619. My lord will see section 5. Lordship got it. Kindly see 6, my lord. At 619.
So head of the department would be
Yes. The district judge will be head of department.
how?
District judge will my head of department, not the district judge will be head of department. Head of the district judiciary. He the head of the district judiciary, district judge. This is what I thought of placing it before the court.
So we dictate.
I'm sorry.
We dictate.
Uh,
Anything? You want to submit? Your submission is over.
yeah, that's.
What is there? He has nothing to submit. We have filed some affidavit again.
Yes, fine.
That's okay. I'll take care of it. If you have not done it, if you have not done it, so this court by way of a judicial order then will be compelled to pass direction upon the Chief Justice to do it. Where is the judgment of that 1967 Supreme Court?
I'll place it. Wait. That is dependent on Bakshi case.
You have a copy of it?
65. That state of West Bengal was dependent on Bakshi. Okay.
You are relying upon which judgments?
Then 1965, AI 1966, SC 447,
Yeah, 1966,
66, SC 447,
47,
paragraph 14 and 16. Then-
16.
Yes.
Then
My lord will kindly look into another judgment. Gujarat, my case, my lord. 1992, 4 SCC, 10.
what is that for?
That is RN Gujarat, that is my lord concurrence to the district ministerial establishment.
You are referring to State of West Bengal versus Nipendra Nath
Bakshi,
Bakshi.
yes. That was the first case.
The Constitution
We
bench.
have got a copy. The Lordship wants the copy.
No, I've asked them to take.
Paragraph 1416. Paragraph 4 is the, yes, facts. 3 points. Paragraph 4 kindly see now. Paragraph 4.
Paragraph.
See paragraph 4. Paragraph 4 of Bakshi judgment. Then actually,
At the final hearing.
I'm sorry.
It starts with at the final hearing.
Yes, correct.
His appeal was
One
confined to
copy
the
is there,
first
if
three
your lordship-
points. The fourth point. Whether the inquiry ordered by the government and conducted by an executive officer of the government against the district judge contravene the provisions of Iman, whether the provisions of so and so could be utilized to extend the service of Bakshi beyond the normally done. The hearing arguments will satisfy me. Now, whether the court
Yes, your lordship sees. Facts are important. My lord, I'll just put it this way.
Hmm.
My lord, what was the case? Whether the state government can invoke the CCS rule in case of judicial officer. That was the case, and the decision which was the judgment of this court, yes, 235 is to be applied, not to be given by general rule in case of district judge. That was it. This was relied upon in
Paragraph?
Paragraph, my lord,
14.
14, 14, 15,
14 is a submission.
yes. 15, 16 now.
We do not accept the
16,
word
16.
control is not defined in the constitution at all in paragraph here, which deals with the service under the union. come to paragraph number 16.
Paragraph 16.
In the case of judicial service subordinate to the district judge, the appointment has to be made by the governor in accordance with the rules to be framed after consultation of the State Public Commission and the High Court. But the power of posting, promotion, and grant of leave and control of the courts are vested with the High Court. What is vested includes disciplinary jurisdiction. Control is useless if it is not accompanied by disciplinary powers. It is not to be expected that the High Court would run to the government of the governor in every case of indiscipline, however small, which shall not even require the punishment of dismissal or removal. These articles go to show that the vesting of control in the High Court, the independence of the subordinate judiciary was in view. This was partly achieved in the Government of India Act, but it was given full effect by the drafters of the present constitution. The construction is also in accord with the directive principles of the state. Then what you were saying about this 309, LNC 17, then next argues that Article 309 to remand
So
give a
311.
clue to the meaning of the word control. The argument is that the legislation regarding service of the state falls within the jurisdiction of the
Given the power to regulate the recruitment and condition of service of person appointed.
But then seems to make no distinction between the legislative and the executive powers. Under Iman, the power of the executive of the state is coextensive with that of the legislative, but all that is the subject to the other provisions of the Constitution. Has the power to make laws relating to the service terms, not so that the executive enjoys corresponding executive power if the Constitution indicates something. Does not make no distinction. Nothing in the compare. Computing the report is outside of the jurisdiction to hold the inquiry. I think the control is vested with the High Court, complete, subject only to the power of the governor and the matter of appointment, including the dismissal and removal, and posting and promotion of the
This is only shown in context of Gujar case, my lord, 235, when we were gone back to this judgment.
Now, if you see the judgment in the
Yes.
case of Registrar General of the High Court of Judicature of Madras versus R. Perichi, this
We
was
have,
as regards a transfer.
yes, we have,
2011-12 versus C1.
yes, we have. 2000, hello, that's what the judgment citation.
2011-12 versus C137.
Well, let's see.
He is on well.
One piece.
Paragraph 28.
Para 28. Para 28.
here in this case, what has happened,
Yes.
the Chief Justice, on account of pending inquiry, transferred him. Now the question, there were two full questions. First was whether the Chief Justice could have done so. The Supreme Court held that the power was exclusively of the High Court, and the High Court, by way of a full court resolution, has empowered the Chief Justice to do so. So therefore, the Chief Justice could have transferred him pending so and so. So that was the question out there, which, however, refers to the again the judgment of again another judgment of 2002 4 SCC 524, wherein it says, which talks about the control under Iman and has been used in the comprehensive sense and includes the control and superintendence of the High Court over the subordinate courts and the person manning them both on the judicial and the administrative side.
Both. One control was that.
এই মোক এইখন দিয়কচোন। 2002 4 SCC 52 2002 4 SCC 52.
The lordship is on only on 235.
We are only on 235. We have nothing. Control of the power is vested held since the ministry. Is by the judge. Thousand two 4 SCC 52. Judgment,
Can your lordship see one more judgment on the control?
State of Odisha versus Sudhanshu Shekhar Mishra.
Well, one judgment kindly look into 2007, this is 9 SCC, page 539.
As sparing the service of a judicial officer to be the government is open to the High Court.
It is possible.
is another important judgment.
But
This is
your
another
lordship is-
constitution,
Your lordship is
1963.
looking into 1997.
68 Supreme Court 647. You referred to that. Huh? Oh, this is the 68 Supreme Court 647.
Yeah.
This is also a constitution bench judgment.
Yeah.
What has now happened? The government, without the judicial officers, were manning certain executive posts.
Hmm.
Now the question arose as to how this process can be allowed.
Hmm.
It's something more like a deputation.
Yes.
Now it says, while the cadre with which we are concerned in this case consists of three parts: presiding officer of district courts, the register of the high courts, and the judicial officers working in the secretariat. No doubt all these officers belong to the judicial service of the state, and they were before 1962 presiding over the district courts or the courts subordinate to them, and as such were under the control of the High Court. Hence, without the consent of the High Court, the government could not have posted them to the administrative post in 1962. It must be presumed that they were taken by the government with the consent of the High Court.
Hmm.
And there it's okay. While sparing the services of a judicial officer to the government, it is open to the High Court to fix the period during which he may hold any executive post. At the end of that period, the government is bound to allow him to go back to his parent department unless the High Court agrees to spare his service for some more time. In other words, the period during which a judicial officer should serve in an executive post must be settled by way of an agreement between the High Court and the government. If there is no agreement, it is open to the government to send him back to his parent department at any time it pleases. It is equally open to the High Court to recall him whenever it thinks fit. If only there is a mutual understanding and appreciation of the difficulties of one another, there will be a harmony. There is no reason why there should be any conflict between the High Court and the government, except for very good reasons. We think the High Court should always be willing to spare for agreed period the service so and so. So therefore, the High Court still continues the power having under 235 and 236. And if there is no agreement between the High Court and the government or this Arunachal Pradesh Human Rights Commission in that regard, the High Court and its so and so, High Court can recall it. Now, if the power is being, the High Court have the issued direction upon the district judge to do so, and the district judge have revoked it on that basis, what is wrong with the order? Here we get the catch. And what else you were showing? Deputation, deemed deputation, with the creation of the Iman, however, procedure for permanent transfer to the corporation as laid by the Iman not yet followed by the employee can be transfer defects. Transfer of service validity, transfer of operation. This is the case. The expression control, although it's
Yes.
not defined in the light of Article 235, has been held to confine the power. Control
Para
implies that
14.
the controlling officer must be in a position to dominate
Para
the
19.
affairs. Para 19, na?
19, 20, 21.
It is unless otherwise defined will be synonymous with the superintendent's mandate. It is exercised by a superior thought in exercise of reality amount to the effective. Now, why this was referred to, means there was a deputation from High Court,
Which one?
from any district judiciary, yeah?
No, this is not that. It's a control, man. What is the control? What do you mean by the expression control? No, this is not a case of High Court
Then why they were referring to 235?
because the In the context of this West Bengal case, Nipendra Bakshi and Gujjar case. Concept of control. So what is the concept of control? Concept of control.
Here the question was as to whether the corporation, what is that corporation name?
Prasar Bharati.
Prasar Bharati
Yes.
Broadcasting Corporation, who means what was happening, these people were actually working in Akashvani and Doordarshan.
Yes.
Now, with the Prasar Bharati coming in, these people continued to work there. Now, these people were transferred by Prasar Bharati. The question was whether Prasar Bharati had the power to transfer, taking into account that they are central government employees. That was the issue, as we can find it in paragraph number 4. Then,
Hello, what is in absence of rule? What happens in absence of rule? That is paragraph 21. Paragraph 21.
have not framed it rule. In absence of any rule, however, an employer, it is well known, would have an inherent power to deal with its employees. In a situation of this nature, we have moved on to the same transfer. It is one thing to say that the employer does not have any power to transfer in No, here the question, the court say that as transfer is an incidence of service, so a transfer can very well happen. Now, it was said that as these people were working, although these were central government worker employees, but as these people were working, they were deemed to be in deputation, sent on deputation by the central government to this.
So what my case, why I was showing this, the High Court has not framed any rules. What I said, no procedure has been prescribed. In what manner? Now I am placed, the power which I am showing is being placed under the FR, which I am saying, under what authority the district judge has. That was my argument, my lord. So in absence of any rule which is not been framed, ultimately it has to be framed by a full court. Chief Justice has to impart, these are the person, in what manner, if a person is sent on deputation.
Mr. Das, we are not concerned with the rule. We are concerned, our specific query out here is as to whether without the concurrence of the High Court,
No.
can any officer be sent on deputation?
No, that was
That's
the
the
first,
issue.
that was the first query.
That's
Secondly,
the only issue.
No, second, no, second,
If
your
you
lordship.
can if
No, no,
you
your
can
lordship.
show that without the High Court's concurrence, any deputation can be sent, deputation or whatever may be, without the High Court's concurrence, it can happen. Then that's the end of the matter. That
No, no.
is the only issue.
No, no, only issue because that was extended. Your lordship, if you just recollect, it was extended to the lordship, he was there. That's what is subject to your lordship, correct me. The lordship said under what authority, under what rule the district judge has sent you on deputation. So now what I have shown that the virtue of the residuary power, he has got the power, residuary power. Now, from where it can be traced? It can be traced under FR. That's my argument before this court.
No,
So if it can be
whatever may be,
yes,
you can trace it to the FR.
yes.
But the question overall is whether without the concurrence of the High Court, can an officer or an establishment, any person, any ministerial staff can be sent on deputation. This is the
But
issue.
in absence of any rules to be
So therefore the
framed.
power is, therefore the question is Article 235.
No, I understand. 234, there is an article, 235.
So if there is no rules for that, only see, the judgment is on the question of incidence of service. Transfer is an incidence of service, but deputation is not an incidence
No,
of
that's true,
service.
but No, now
So therefore, if a person, it is on a deemed deputation, which has happened here. It is a deemed deputation, but we are not on that question. We are on the question is whether there can be a person, judicial officer can be transferred without the concurrence of the
So
High Court.
that was an issue which we raised on the first point. On the second point, your lordship has raised. What we have raised is that how a power can be traced. It is by the Power Act 2013 by virtue of a rule. That's what I am saying, my lord. In absence of any rule which is not framed by the High Court, maybe under 235 there is a control. There is a supervisory power, but there is no rule which has been framed. Now, if your lordship looks into it, 15 of the judgment of 1997, 3 FCC 11.
Well, judgment is additional 2002 for SCC, so good go. Waiting. This judgment is very relevant. Guwahati High Court versus Kuladhar Foucault. This is on the question of deputation. Let us look into this. This is directly on the. You got it?
So Guwahati High Court versus Kuladhar Foucault, 2002.
Paragraph 7.
Paragraph 7.
The controversy erupted when, on 23/2/1995, the High Court informed the government of Assam and the respondent number 1 of its decision to recall the respondent number 1 to his parent department, and thus, and that a suitable substitute in place of respondent will be provided in due course. On so and so, the register judicial once again requested the state government to take immediate steps to replace the services of the respondent number 1 at the disposal of the High Court, so that the officer could be repatriated and be posted as Assistant District and Session Judge North Lakhimpur on so and so. Notified the posting of here. And here, respondent number 1 sent a communication to the register there, wherein first time he stated that he was a direct recruit in the Assam Legal Services to the Assam Public Service Commission, and that he expressed his desire indicating his option for permanent absorption in the Assam Legal Service. It was further stated that it was expected that his service in the Assam layer would be confirmed by as the Honorable Minister Law had ordered for such confirmation. He then requested for his posting as judicial officer being cancelled. So this was the dispute.
Mm.
Release respondent number 1 from the post of the joint remand and join it so that he could join as so and so. However, the state government released it. Pursuant to the notification, it appears from the said above notification. Now, kindly see from here, does not wish to be repatriated, so he challenged it.
Yes.
All these things have been taken. Then paragraph the court looked into the scope of 235, 14, 15, 16. Then kindly come 18. An ad hoc appointment required to be made immediately in the public interest. 19. The appointment of the respondent number 1 as Deputy Secretary in the Assam Legal Services, Grade 3, was made initially on a temporary and ad hoc basis to satisfy the immediate need of the state government. For that purpose, the application by the respondent seeking such appointment was forwarded by the High Court, and his services were also spared for taking over the new assignment. However, thereafter, the respondent number 1 in the state government gave a complete go-by to the constitutional requirement of consultation. While seeking an appointment on regular basis as Deputy Secretary, neither the respondent number 1 felt the need of having his application forwarded by the High Court, nor did the government feel the need of consulting the High Court, though mandatorily required by the Constitution, as also by Rule 7 quoted above. Similarly, while promoting correspondent number 1 from grade 3 to grade 2 of the Assam Union and appointing him as the joint secretary and the legal member, the High Court was not consulted, merely because the state government sent a copy of this notification to the High Court. The requirement of consultation cannot be said to have been satisfied. Neither was it initiated by the state government, nor did the High Court exercise, avail, or discharge its power, privilege, and obligation of consultation. An invalidity caused by failure to comply with the mandatory constitutional requirements such as consultation cannot be cured by sheer inaction on the part. In almost all the states and union territories in the country, services of judicial are loaned by the High Court to the government for being utilized in litigation, judicial, Law and Legislative Affairs Department of the government by whatever name the department. The Secretary Law the Remembrance serving under the government is a judicial officer whose services is given. He is a vital link of communication between so and so. As held by the court in so and so, the state government requesting the services of a competent judicial officer being made available to it, and the High Court conceding to such request is by consent and willingness of the two. Neither can the High Court be compelled. This I read it from the judgment.
Yes.
We are therefore clearly of the opinion that there is no merit in the plea that the service of the stood absolved in so and the High Court could not have recalled so and so's deputation. Equally meritless is the plea of the lien of the respondent number one in the state judicial service had come to an end and he had acquired a lien in so and so. The division was unnecessarily influenced by the factor of the High Court having recalled on so and so its notification, ignoring the reason behind the recalling. The notification posting as a judicial order had to be recalled as was not carried out and required to be recalled so as to another notification filling up the year lying vacant. So also the division ignored the impact of the constitutional provision while forming an opinion that the lien of year in judicial stood automatically terminated as the appointment to the legal service whilst he was a member of EA was made without consultation and hence was valid. Mr. Mr. Monto, then in that case you don't require we terminate the lien of him.
My lord.
You see, this observation made by the High Supreme Court is very clear. Now, what had happened in this case, this person went there. Now, when he went out there, he said that he has already been absorbed, he has been taken out there. Now, without consultation of the High Court, when he went out there, the Supreme Court says, so the division bench ignored the impact of the constitutional provision while forming an opinion that the lien of Jaya stood automatically terminated as the appointment of Jaya whilst he was a member was made without consultation. The question of acquiring a lien in legal service and lien in judicial service being terminated did not arise. The judgment of the division bench of cannot be sustained. The constitutional and legal provision have been set at rest. The question which still remains to be decided is the manner in which the relief should be constructed. In order the relief so and so. Submitted ever since the year for a period of less than a year, he remained in the post of legal service and now he is nearing the end of his career. So we dictate now. So you were showing some judgment, Mr.
No, that's the question.
Okay, let us dictate. Mr. D. Das, the learned
One
senior
judgment,
counsel.
for the civil consequences, there is one judgment.
Huh?
Civil consequence, because my recalling order, when they have recalled it, without giving any notice, they have recalled it. So if.
No, there is no question of
I'm
the
just-
question of civil consequences does not arise when it is a non-est
No,
order.
no, if it is administrative, if it is on the administrative side or a judicial side, my lord, the civil consequences follow. I'll just place one judgment of the Supreme Court. The 2008 14 SCC, case 151.
2008,
2008 14 SCC, page 151. Paragraph 15, 17, 18, 21, and 30.
what is that?
This is civil consequences.
Hey, Edla Stenoso judgment that are decision. Reported 2025 to JLR. By 2 JLR. So you say that the notice ought to have been
Yeah.
given.
This is, and one more is DK Yadav, 1993, 3 STC, page 259.
What does it say?
This is again principle of natural justice. While you civil consequence recalling of order, it leads to a civil consequence. So paragraph 14 kindly be looked into. Directly paragraph 14.
It's a case of termination.
Yes, maybe the
I'm not
no,
terminating.
it's a principle. Principle of natural justice,
It's
be it a
natural justice.
termination or recalling of an order.
Okay, I'll take care
Principle.
of that.
Yes.
Yes, what do you have to say? Ah, please come here. Hey, February, March, CLR issue to the judgment of the stenos. Judgment.
The other day also Malad was asking me whether we are going to release. Malad, it's indeed
Now you say that
a difficult.
it is dependent upon the final decision of this court, and as such, the question of releasing now does not arise till this court decides. That's
And
your submission.
That is one part, my lord, and since we have filed affidavit, my lord, and our stand we have brought on records, my lord. Just for a moment, may I rely on uh, paragraph 19, subparagraph G, my lord, 121 page.
What does it say?
May I learn? It is hereby submitted that once a deputation is admitted on deputation into an organization, he or she should be allowed to complete its full term. However, the same is subject to one exception only. The clause 9 of the office memorandum, Department of Personnel and Training, dated 17/6/2010, issued by so and so forth, by the Government of India, Ministry of Personnel. Lordship will find the relevant page of the office memorandum, my lord.
Page
It's
One?
page 170, my lord.
170.
Yes. Relevant page is, my lord, 179. 179 page. Affidavit of R5, my lord. Para 9, my lord. May I read, my lord? Premature reversion of deputation to parent cadre. Normally, when an employee is appointed on deputation/foreign service, his services are placed at the disposal of the parent ministry, department at the end of the tenure. However, as and when a situation arises for premature reversion to the parent cadre of the deputationist, his service could be returned after giving an advance notice of at least 3 months to the landing ministry department and the employees concerned. In this particular case, my lord, we were not given notice. This only after 2 months, my lord, after completion of two months of service, my lord, deputation. We were given notice, my lord. That notice was not backed by any cause and reason, my lord. A simple request for release, my lord. Lordship will find that at page 152, my lord, letter of release.
ব্যক্তিটা দিয়কচোন। The yellow marker to put there.
One 148 page, my lord.
On
Not one.
48.
148. not, sorry, my lord, not one.
This is your reply. You have,
Page 152. With reference to the above, I am to inform you that the Registered Vigilance Guwahati High Court on 2012 to 2024 directed your board office to release Mr. So and so forth, who is presently deputed in your.
but before that also, you have started writing
My lord,
that don't reconsider the decision. You started writing to the district and session judge for reconsidering, even to the high court for reconsidering.
because my lord, notice to the State Human Rights Commission was without any reason, my lord, cogent reason.
But you are not on, you are not filed a writ petition. No?
Whatever, my lord,
Now, are you going to, you are
Because-
filing what?
placing the factual position, my lord.
Anything else?
Anything else, my lord? The State Human Rights Commissions cannot be met, my lord. My lord, casualty of the High Courts having no rule, since the High Court is such a old institution, my lord. They should have the rules, my lord. Because of the ambiguity in the procedure, my lord. All this have happened, my lord. And for that, we should not be penalized, man. State Human Rights Commission is there, is also a statutory.
Well, what is your penalty?
No, we are,
No, no, I am
will be made to
I'm
suffer, my
asking
lord,
you,
because
what
we
is
have-
your penalty? Your penalty is the petitioner is going through a disciplinary proceedings. Is that your penalty? No, I'm asking.
no, no, we are not into that, my lord.
No, no, what
Suspension
is your
and all.
penalty?
Because we have done the recruitment process through a proper channel, my lord, with, by following due procedures of law, my lord.
So,
And also we have sent the deputations to training, 2 months training to National Human Rights Commission. We have spent lot of money on the deputation. Who will bear the cost of this? Who will compensate?
you
state
sent
government?
it on Human Rights Commission.
Yes,
When?
it is there in the affidavit, my lord.
When? Show me. Let me put that also in your submission.
Right.
Where is it?
How come? Para 13, page 113. Annexure J.
3 days. 2 months, why are you saying 2 months? You have
No, no,
not
I'm
read
sorry,
it
my lord, not
properly.
2 months, my lord, 3 days.
3 days.
No.
To Delhi.
Yes, my lord, National Human Rights Commission.
Hello? Approval for which was issued on 4/11
Yes.
by the APSRC. And the training was conducted on so and so and so and so. Why did you send to training? By that time it has been recalled, isn't it?
My lord,
It has been recalled in the meantime. When was it recalled?
24th, 20th September,
Huh?
20th September.
When?
Recalling order. Page 64 is a recalling order. 28/11. Recalling order. 28th of November 2024. At page 64 of my petition.
28th. So in the meantime, you have Hello, we direct the district judge to pay you that amount. You should be satisfied with. Some penalty has to be given to the district judge in charge, so he'll pay you.
Not saying in terms of money, my lord.
That is the money you are saying. You see, you are more concerned with the money. You are more concerned with the disciplinary action against the petitioner. So therefore, the question is what? Either you are concerned that you have sent it for deputation of this for 2 days,
3 days.
3 days, because a person has to go, na? Did he? And this deputation will help her when she is there back in Alu. Don't you think so? That the Arunachal Pradesh Human Rights Commission should do something good. Anything more?
That's it, my lord. That's it, ma'am.
Yes, Mr. Monto. Any submission on the legal point? Or are we say that like the High Court on the administrative side, the High Court on the
235, your lordship, kindly see purely. my lord,
Standing Council of the High Court is also in such shambles.
No, my lord, actually there is no provision for deputation in my lord. That order itself is known as my lord. That is, your lordship kindly see 235. 235 is a control of order judiciary, my lord, subordinate court, as well as my lord, district court and subordinate court, as well as my lord, ministerial staff also. So my lord, if district judge, my lord, without informing anything, my lord, he is doing his part, my lord, there is no meaning of Article 235, my lord. Exactly what happened in this case, my lord, your lordship kindly see, since I am the district judge, I have given a permission, there is 235 is, what is the meaning of control, my lord? Article 235, your lordship kindly see that, my lord, control over subordinate court. My lord, it implied that, my lord, anything you have to done, you have to take permission, my lord. Although there is no specific rule, when there is no provision for the, my lord, deputation, there is no question of any prescription, my lord. So that was the question raised, my lord, there is no prescription. When there is a provision, then question of prescription is there. In respect of our the principal seat, my lord, there is a one administrative committee's, my lord, resolution. And that, my lord, my lord, that I have annexed, my lord, probably.
But that is only for the principal seat.
Principal seat, but it was circulated to all outlying bench also. So same yardstick has been applied to the all.
Yeah, High Court on the administrative side should be more active than
That,
maybe
of
they
course, my lord, but
maybe the judges
some-
who are there manning it.
but they are,
be
my
too
lord,
busy writing judgments
My
so
lord.
that they don't have time.
but my lord, without informing, my lord, some judges or district judges are not doing in their part, my lord, then, my lord, there is no meaning of control, my. So it is purely Article 235.
This district judge has sent somebody on deputation. Tomorrow the district judge may also say
My lord, exactly.
that I am the head of the department.
So I can, without taking permission from the High Court, I
chief
can do it.
judicial magistrate who is there, let him join out there in the government. They can say so.
Then, my lord,
Because they will come within also the ambit of the rules.
that act will frustrate, my lord, Article 235, the
If
control.
he is considered, if we go by the submission of Mr. Das, the district judge is the head of the department.
My lord.
In turn, and applying what he is submitting to the rules, which not only applies to judicial officers, but also to the ministerial staff.
Minister.
The chief judicial magistrate would come under the district judge.
My lord.
And therefore, he being the head of the department,
He can transfer,
he can, no, he
Then
not only he can transfer,
send
we
deputation.
can send him to deputation. That go there, you be there.
If they complete go by to Article 235.
Huh?
Complete go by to Article two thirty-five.
Not necessary, the district judge will do. More reply.
My query again, my rebuttal is only in absence of any rule. That will be same, in absence of any rule which is not framed by the High Court, my lord. Correct. So this is the query that was put forward. 235, no doubt there is a power of concurrence, but without framing any rules by the High Court.
Concurrent of what?
No, the supervising power of the High Court, control of the High Court
Rule.
under 235. Now, my lord, without framing any rules by the High Court. Now.
So therefore, as I was putting him the example, the district judge can send the chief judicial magistrate.
Of course, if it is permitted. No. What I'm saying, that if a rule provides, but there is a rule which has been provided at the residence.
No, so therefore, in the state of Arunachal Pradesh, if we apply your submission, the district judge, can the district judge send the chief judicial magistrate on the deputation?
No, there has to be appointing, my appointing authority in this case is a district judge. He has provided.
Therefore,
the head
where
of
is
the
the,
department.
where are you finding out that it is the appointing authority who is the head of the department?
Yes.
Right.
My appointing authority is a district judge.
Understood, but
Yes.
the office memorandum which you are referring to
Yes.
does not say anything about the appointing authority. It says the head of the department.
But
So are you saying therefore, if we apply that, it
Yes.
doesn't say appointing authority. It says head of the department.
it's your lordship indicative. Head of department means the High Court.
No, I'm not saying that. I'm saying, therefore, if we apply your submission that it is the head of the department, it doesn't say the appointing authority can set. That this memorandum
Yes,
which
I
you are
have seen,
referring
yes,
to,
yes. That's the
this
FR.
one which you are
FR.
referring to,
Yes.
does not say anything about the appointing authority. It says the head of the department.
Submission to this immediately reply will be head of department means will be my head of department, being the appointing authority will be the head of department. That's my submission. No, for judicial.
So
officer-
therefore, you are again saying that the another word has to be added to this office memorandum which you are relying upon, that the head of the department also will mean the appointing authority.
Well, I am not saying that. But what I am saying. in
Because
this-
here you are relying into a
Yeah,
clause.
I am relying to a particular.
What was the page?
But
what was the-
619 of the.
It has been decided that the power of deputation in respect of non-gazetted officers may be exercised by the heads of the department. And in that respect, the gazetted government servants by the ministries of so and so. So therefore, you are saying the head of the department would be the,
My lord, if this is the rule of this 2013 rules, and if you go by 2013 rule, that rule has been framed, by the legislature has framed the rule, recommendation is given by the High Court. Now, even if there is a power, a residuary power is under 29, if it is under 29, then why this cannot be applied? That's my question, my lord.
so therefore you are
then-
saying
then
the
my
head
lord-
of the department means the appointing authority.
That is my submission, one. Secondly, what my submission is that this particular rule has been framed by legislature. Recommendation is given by the High Court. The High Court also knew that there is a provision on 235 to 36. High Court, while recommending, they should have think of,
Consultation.
no, they should have think of that if that be the case, that recommendation should not have been given because there will be a direct conflict. There will be a direct conflict with the FR or any of the office memorandum. That means there is no question of applying office memorandum or any rule. Directly, it has to be consulted on the 235, 230. That's my submission before this court in rebuttal. That's my submission.
Because, Mr. Das, what you are submitting, it reminds me of a judgment of Justice D.Y. Chandrasud in Mohit Minerals,
Yes.
where the petitioner councils were trying to interpret a provision of the Constitution, which is pertaining to the GST, on the basis of the provisions contained in the Central GST Act. The Supreme Court say that a constitutional provision is to be decided on the basis of the provision itself and not on the basis of its subordinate legislation. A decision, a constitution is made on the basis the power is given by way of by the Constituent Assembly, which stands on a higher pedestal compared to a legislative enactment like even as made by the Parliament. Though both the Parliament, it is both the Parliament who is doing it, who has the power. The Parliament has the power to amend the Constitution. But when it makes an amendment to the Constitution and thereby brought in Article 272, then in that amendment cannot be tested on the basis of the CGST Act, though it is the Parliament, because the power of constitutional, making a constitutional amendment and power of a. Now here we are concerned with a 309 rule.
But what my submission is that because your lordship that they have asked me regarding about under what authority the district judge has sent you on deputation. Whether it is traced by any rule. That was the question that was asked.
The
why
district
I-
judge refers to an office memorandum.
That I said, I have gone through that office memorandum. That office memorandum. is
That
not-
office memorandum is not applicable, which I have also mentioned in my earlier order itself. In view of clause 3.1 and 3.2, I
No,
categorically
no.
mentioned,
This is,
but the district judge has done so.
no, thereafter, I checked and I found that no, it is backed by some, the source of power is traced on the basis of a fundamental rules. That's why I have placed before this court.
So this is not even a fundamental rule. This is not a fundamental rule. It is this is what?
Rule 9. Rule 9 of the FR.
This is section, what is this section for? This is in
Your lordship
appendix.
kindly see, rule 9, there are a lot of sections are there. Sub rule 25. It has been formulated, this is under the Government of India Act 1935.
Where is the deputation provision?
Deputation will find in 619, 619.
619 is okay, but
No,
there is
sir.
a provision
No,
for
there's a heading is there. There's a deputation. Power. 619. Section
no. Rule 51. Rule 50, 50 and 51. Deputation out of India.
You see, I'm not very sure. 110 to 127, maybe.
Huh?
110, what I just recollect, 110 to 127. Not very sure, but it.
Ten is foreign service. Okay,
That's not my rebuttal, matter of this point.
let me come back. I'll
Yes,
dictate
I
the
just
judge.
that point out about before your lordship rise, what we are saying again, troubling the court and rebuttal to that. The rule of 2013, which your lordship we have read, that rule 3 of 3, who is the appointing authority, and district judge being, and in pursuance to that, uh, the 29, 28. If you see 28, I just quick change of cadre. Uh, Stenographer of all grade who have put in such number of years of service, maybe special high court, may be permitted by the appointing authority to change the cadre to a cadre of equivalent post on a clerical or ministerial side. So appointing authority will be the district judge. Now, if you see 29, residuary power, the condition of service of member of service for which no express provision is made in this rule shall be determined by the law, rules and orders for a time being applicable to the member of the state civil serving the state holding equivalent grade post. So that is the source of power which we have traced. The
Now, Rule 28 has no relevance.
residuary power
Now,
in the
29, 28 is for changing the stream.
Yes,
A person may be, a stenographer may be working with, in the judicial side.
that is what I'm saying. The appointing authority has got the power, the power. So district judge has got the power
Or
for changing of a cadre from one cadre to another cadre. District judge
but within his establishment.
within his establishment.
So within his establishment, he can do so.
Yes,
There's
that
no
is what-
quarrel with that. But for that to give or send
No,
somebody from
No,
deputy,
what I'm saying, their power, now I will repeat again, my lord, their power is vested and that recommendation is given by the High Court. It is a virtue of section 29. 29 residuary power is there. So rule that provides the residuary power. And knowing it very, the High Court knew you about the residuary power under 29. That's my submission.
let me come back.
Yes.
Mr. D. Dutt, the Revenue Senior Counsel, assisted by Mr. K. Mohammed. Learned counsel appearing on behalf of the petitioner, Mr. Stapin appears on behalf of the respondent number 1, Mr. T.J. Mohanto, the learned senior counsel, assisted by so-and-so, who is the standing counsel of the Guwahati High Court. Learned senior counsel is the standing counsel of the Guwahati High Court principal seat. Appears for the respondent number 2, Mr. Mukherjee, the learned senior counsel, who is also the standing counsel of the Guwahati High Court. Itanagar Permanent Bench appears on behalf of the respondent number 3 and 4, and Mr. S.R. Rabha, who appears on behalf of the respondent number 5. The issue involved in the present proceedings is as to whether a member of the ministerial staff of the district judiciary can be allowed to go on deputation by the district and session judge without the concurrence of, without the approval of the High Court. First, for deciding the issue so involved, it is relevant to take note of the brief facts which have led to the filing of the instant proceedings. The petitioner herein was appointed as to the post of Pescor by an order dated 21/12/2015, pursuant to a selection made by the recruitment cell of the Guwahati High Court on the basis of an advertisement dated 18/7/2013. The petitioner was posted as Pescor, posted at in the establishment of the Court of the Chief Judicial Magistrate, cum Civil Judge, Senior Division, Alo, West Siang District. Full stop. An advertisement was issued on 26/12/2023 by the Arunachal Pradesh State Human Rights Commission, hereinafter referred to as the Respondent number 5, for filling up of 4 posts of assistant by 100% appointment on deputation or by analogous post of officer in the pay matrix 5. The petitioner, having eligibility, sought approval for applying for the appointment on deputation to the post of the assistant from the Chief Judicial Magistrate cum Civil Judge, Senior Division, Alo, West Siang District by application dated 22/1/2024. The Chief Judicial Magistrate cum Civil Judge, Senior Division, Alo, West Siang District forwarded the petitioner's application dated 22/1/2024 to the District and Session Judge, Alo, West Siang District, Arunachal Pradesh. At this stage, it is very pertinent to take note of that there was no officer appointed at that point of time as the District and Session Judge, Alo, West Siang District, Arunachal Pradesh. However, the charge to the said post of District and Session Judge, Alo, West Siang District, was given to the District and Session Judge, to the officer who was holding the post of District and Session Judge, to the officer who was holding the post of District and Session Judge, East Siang District, Pasigat. Namely, one, Mr. Tageng Pado, Padoh. upon receipt of the said application which was forwarded, comma, the district and session, the said officer, namely Mr. Tageng Pado, put a note in the said application dated 22/1/2024, stating inter alia, stating, inverted comma, controlling officer may comply with the prescription. What is that? Prescribed. Huh?
Time on form.
Hmm. State somewhere.
What man? It is at page 51.
51, I understand.
51
What is
only.
this? Controlling authority may
Controlling
comply
officer may
with
comply,
huh?
comply
With the
with, which may, with,
prescribed,
comply with the prescribed form of
certified on with
On
NOC
with-
of the applicant and go on deputation.
yes.
Somewhere he stated that.
I think in his affidavit, he may-
In his reply,
yes,
he has stated that. I remember.
yes.
Uh-huh.
In a form.
Stated there may comply with the prescribed form of certification with NOC of the applicant
To go on deputation.
to go on
On
deputation, inverted comma close. On the basis of such authorization given by the said officer, namely Mr. Tadeng Podo, comma, the district and session judge in charge, the chief judicial magistrate, come civil judge, senior division, West Siang district, filled up the application certified the application of the petitioner, which was thereupon certified the application of the petitioner on 25/1/2024. And on the basis thereof, the petitioner submitted the application to the secretary of the respondent number 5 on 30/1/2024. The respondent number 5, pursuant to the said application, sought for various documents from the Chief Judicial Magistrate cum Civil Judge, Senior Division, West Siang District, via the communication dated 10/6/2024, which included, number 1, annual performance assessment report, bracket upper, for the last 5 years. Number 2, vigilance clearance certificate. Number 3, integrity certificate issued by the head of the department. Number 4, pay matrix level as on date and the date of entry in the present pay matrix. And number 5, the promotion order of the applicant to hold to the post held at present. The Chief Judicial Magistrate cum Civil Judge, Senior Division, West Siang District, forwarded all the said documents as sought for by the communication dated 10/6/2024 to the Undersecretary of the Respondent number 5 by the communication dated 21/6/2024. The record reveals that on 9/9/2024, the respondent number 5 appointed the petitioner to the post of assistant for a period of 3 years, initially on deputation basis, with effect from the date of her joining the post of assistant to the secretary, joining to the post of the assistant to the secretary of the respondent number 5. Pursuant thereto, on 18/9/2024, the officer, namely Mr. Tageng Pado, who was still holding the charge of the post of the district and session judge, West Siang District, Alo, released the petitioner from the establishment of the Chief Judicial Magistrate cum Civil Judge Senior Division, Alo, with immediate effect for her to join her new department. Full stop. At this stage, it is very pertinent to mention that in the entire process, there was no information so provided, information in the entire process since the date of submission of the application by the petitioner, dated 22/1/2024, till 18th of September 2024, the Guwahati High Court was kept at dark. On the administrative side, was kept in dark. It was only first on 18/9/2024, after releasing the petitioner, the copy of the order was marked to the Register Guwahati High Court, Tanagar Permanent Bench, UPA, for information. On the basis of the order of release dated 18/9/2024, the Chief Judicial Magistrate cum Civil Judge Senior Division, West Siang District, issued the release order dated 20/9/2024, whereby the petitioner was released from the establishment of the Chief Judicial Magistrate cum Civil Judge Senior Division, Alo, with effect from 20/9/2024, bracket F/N, to enable her to join in the establishment of the Arunachal Pradesh, establishment of the respondent number 5. Full stop. The Chief Judicial Magistrate cum Civil Judge Senior Division, West Siang District, however, did not find it appropriate to even mark a copy of that release order to the Guwahati High Court. Next. The petitioner thereupon submitted the joining report to the Secretary of the Respondent number 5 on 23/9/2024. Full stop. The respondent number 5 duly acknowledged the joining of the petitioner on 23/9/2024 by the communication dated 9/10/2024, issued to the Principal Secretary Home, Government of Arunachal Pradesh, by the Undersecretary of the Respondent number 5. Pursuant thereto, On 28/11/2024, the District and Session Judge, Western District, issued an order whereby the release order of the petitioner was recalled or revoked with immediate effect and directed the petitioner to join the office of the Chief Judicial Magistrate cum Civil Judge Senior Division Alo within 7 days from the date of the said order. Full stop. The said order dated 28/11/2024 is it has been impugned in the incident proceedings. It is very pertinent, however, to take note of that this order, impugned order dated 28/11/2024, was issued by the district in sessions issued by one Jaweplu Shai, who was the incumbent duly appointed to the post of the district and session judge, West Siang District, Alo. The petitioner, on coming to learn about the said order, dated 28/11/2024, submitted a representation on 3/12/2024 for reconsideration of the revocation recall order dated 28/11/2024. The respondent number 5 also issued a similar communication on the same day, that is on 3rd of December 2024, requesting the District and Session Judge of West Siang District to reconsider the recall revocation of the release order of the petitioner. The respondent number 4, thereupon, by the communication dated 4/12/2024, rejected the representation of the petitioner as well as the request so made by the respondent number 5 for reconsideration of the impugned order dated 28/11/2024 by the communication dated 4/12/2024, and the respondent number 4 further directed the petitioner to join her office, that is the office of the Chief Judicial Magistrate Court, Alo, immediately. It is relevant to take note of that in the said communication dated 4/12/2024, it was mentioned that the said request for reconsideration cannot be done in view of the fact that the said order of recall revocation, said impugned order of recall revocation of the release order was issued on the directions of the Guwahati High Court on the administrative side. First, the petitioner thereupon submitted a representation to the respondent number 2, seeking reconsideration of the revocation of the recall letter dated 26/11, 28/11/2024. The grounds stated in the said representation were that the petitioner had difficulties in performing has personal difficulties in carrying out the work at Alo in view of the fact that her mother-in-law is a widow residing alone in Itanagar from daily old age ailment and requires constant care. Full stop. Additionally, the petitioner also stated in the representation that managing small children alone in Alo without the husband's constant presence poses challenges, and revoking my services and revoking her services from the respondent number 5 would deprive her children of their full-blooded father, of the love of the father. Yes. The said representation so submitted to the respondent number 2 was rejected, duly informed to the petitioner by the communication by the register of the Itanagar Permanent Bench of the Guwahati High Court by the communication dated 10/11/2024, and the petitioner was further directed to join the office of the Chief Judicial Magistrate cum Civil Judge Senior Division Alo, West Siang District immediately. The petitioner, however, did not join, but continued with the services before with the respondent number 5. Under such circumstances, a show cause notice was issued on 10th of December 2024, asking as to why the disciplinary proceedings should not be initiated against her. The petitioner submitted a reply on 17th of December 2024, stating that recalling of the revoking of her appointment without no, stating that she was fully acquainted and comfortable with the office protocols and administrative functioning of the respondent number 5, and she attended human rights capacity building trainings at National Human Rights Commission, New Delhi, jointly invested by the respondent number 5 and the National Human Rights Commission, which would benefit the state. She further stated that she was released by an order dated 18/9/2024 by the District and Session Judge Alo, and thereupon, if the recalling of the revocation order, thereupon the recalling of the revocation order was made without, for no fault of the petitioner. Subsequent thereto, a disciplinary proceedings was initiated against the petitioner by an order dated 19/12/2024, and the petitioner was and a memorandum of charges were submitted, oblique charge sheet was submitted against the petitioner. First, the petitioner submitted a written statement of defense in the said disciplinary proceedings. And it is under such circumstances the petitioner has approached this court challenging the revocation, challenging the order dated 28/11/2024, whereby the release order was revoked and consequently also have assailed the disciplinary proceedings which have been initiated against the petitioner. First, it is relevant to take note of that when the writ petition was filed on (25/2/2025), it is relevant to take note of that after the writ petition was filed by an order dated 6/3/2025, this court issued notice. First, the petitioner, though, prayed for an interim order for stay of the disciplinary proceedings. However, by the detailed order dated 6/3/2025, the said disciplinary proceedings was not stalled. First, the record reveals that the respondents numbers 1, 2, 4, and 5 have filed their respective pleadings. First, the stand of the respondent number 1 in the affidavit filed on 19/5/2025 is that the petitioner's deputation as assistant to the Arunachal Pradesh to the respondent number 5 and the subsequent revocation of the release order pertained to service management under the control of the judicial administration. It was mentioned that the law department of the government of Arunachal Pradesh plays no role in transfer, posting, or deputation matters of the court staff. Such decisions lie entirely with the administrative jurisdiction of the High Court and the district judiciary. It was further mentioned that as per the Arunachal Pradesh State District Court Service Rules 2013, administrative control of Group C staff, bracket, including matters of recruitment, transfer, deputation, and discipline, bracket close, rest with the district and session judge, and Group A and Group B rest with the High Court. At paragraph number 9 of the said affidavit, it was mentioned that the Arunachal Pradesh District Service Rules of 2013, hereinafter for short referred to as the Rules of 13, was forwarded to the Register General of the Guwahati High Court by letter dated 15/3/2011 for obtaining the approval of the Chief Justice of the Guwahati High Court and the Guwahati High Court by letter dated 13/11/2013, sent the approved copy of the service rules to the Secretary Law. It was mentioned that the approval of the Home Department is not required to release the petitioner, nor communicated letter dated 21/2/2025 is meant for any approval for release. This aspect of the matter would assume importance while this court will be dealing with the affidavit in opposition filed by the respondent number 5. Be that as it may, paragraph 9 of the said affidavit in opposition filed by the respondent number 1 is reproduced herein under page 246 and 247 of this. The respondent number 2 had filed its affidavit in opposition on 14/5/2025. Wherein the stand taken is that the subordinate judiciary, including the district courts of Arunachal Pradesh, is under the supervisory and administrative control of the Guwahati High Court. Therefore, by parity of reasoning and administrative discipline, the same principles laid down by the wherein it was mentioned that the Guwahati High Court in its administrative side had issued a notification dated 1/6/2011, wherein it was categorically mentioned that no application made by any member of the staff of the principal seat at the Guwahati for going on deputation would be entertained except with the specific approval of the administrative committee. It was mentioned that the said decision was given effect to from 11/4/2011. In that context, it was mentioned that the subordinate judiciary, including the district courts of Arunachal Pradesh, is under the supervisory and administrative control of the Guwahati High Court. Therefore, by parity of reasoning and administrative discipline, the same principles laid down by the administrative committee are applicable mutatis mutandis to the subordinate courts in Arunachal Pradesh as well. It was also mentioned that in another meeting of the administrative committee held on 25/5/2011, it was resolved that the Registrar General will notify the staff of the Guwahati High Court about about the decision that without the approval of the administrative committee, no officer, no member of the staff of the principal seat of the Guwahati High Court would be allowed to go on deputation. It was mentioned categorically that the petitioner, it was stated categorically that the petitioner was not appointed on deputation to the post of assistant under the respondent number 5 after following all due process. Inasmuch as the petitioner did not obtain the requisite no objection certificate from the competent authority, that is, in concurrence with the Guwahati High Court. It was mentioned that the deputation of the petitioner lacks compliance with the established procedure and is therefore not legally sustainable. At paragraph number 11 of the said affidavit, it was mentioned that the sole ground for issuance of the revocation order dated 28/11/2024 was that it was done pursuant to the directions from the Guwahati High Court. The said revocation was necessitated due to the petitioner's failure to obtain the requisite no objection certificate through the proper channel and in absence of or prior concurrence or approval of the Guwahati High Court. May come back.
Just 5 minutes, my lord, you are not sure, allow me now.
No, you go.
No,
No, this will take some time. This will go till 3 o'clock. You take your time, you do it. Let me do it. Your junior is there now who will,
Yes,
if I didn't, do not put the submission, he will put it out there. No. Number 44. Very good. The respond number 4, filed an affidavit in opposition on 14/5/25. Wherein it was stated that irregularity had been committed and the rules, norms have been violated while applying for appointment on deputation to the post of assistant by the petitioner. As the court was already in dearth of stuff for which the staff could not have been sent on deputation to other departments. It was mentioned that in the history of Arunachal Pradesh judiciary since separation in the year 2010, till date, no staffs have been called on deputation from other departments to meet the dearth of staff of the judiciary. it was also mentioned that on account of the limited staff, there has been a requirement of making and adjusting them to do various multitask for the judiciary to run the courts. And till date, on account of the petitioner having been allowed to go on deputation, the office, the court of the CGM Alo was facing huge dearth of staff, staff, full stop. To the said affidavit in opposition, the reply sent by the Sri Tageng Pado, who was then the in charge district and session judge, who was the incumbent district and session judge, who had issued the release order, was enclosed as Annexure A. This court had perused the said reply submitted by the submitted dated 27/9/2024, wherein the concerned district judge had justified the release order on the CCS rules oblique office memorandum dated 30, on the basis of the CCS rules oblique office memorandum dated 30/8/2024. And had further stated that there should be a direction issued by the register of the Itanagar permanent bench and further stated that he was ready to recall the release order provided the register Itanagar permanent bench provided him, furnished to him the related documents of the rules to obtain prior approval from the Guwahati High Court. The said officer further went to the extent to state that he did not have any grounds to recall it unless he's convinced that a prior approval is required. The respondent number 4 further stated in the affidavit, further justified in the affidavit, that the revocation, the impugned order of revocation of the release order was justified as the same was not done with the concurrence and approval of the Guwahati High Court. The respondent number 4 further justified that the disciplinary action was also taken on account of the petitioner's having not joined the services, joined the post in the office of the Chief Judicial Magistrate Alo, in spite of various directions being issued from time to time. First, the respondent number 5, next, had filed an affidavit in opposition on 3/4/2025. Wherein, apart from stating the facts which have been already mentioned herein above in the writ petition, it was categorically mentioned that the petitioner, along with the few officials of the State Human Rights Commission, were sent for in-room training for a period of 3 days on human rights at the National Human Rights Commission, Delhi. And the training was conducted from 18/11/2024 to 20/11/2024. It was the respondent number 5 further stated in the affidavit that the disciplinary proceedings so initiated against the petitioner was not in consonance with Rule 21 of the CCS CCA Rules 1965. Inasmuch as the respondent number 5, being the borrowing authority, only had the power to initiate disciplinary proceedings during that period. It was further mentioned that in terms with the office memorandum dated 17/6/2010, the lending department is to give 3 months advance notice to the borrowing department. And without the said being done, the question of revocation of the release order does not arise. It was further mentioned that without Mr. Rabha, where is the paragraph you have stated that without taking the state government's approval, it cannot be done? Which paragraph was that? Ah, it was further stated specifically at paragraph number 18 of the affidavit of the respondent number 5 that the respondent number 5 cannot release the deputationist, the petitioner, without prior approval of the state government. Full stop. This statement made in paragraph number 18, however, appears to be contrary to the affidavit filed by the respondent number 1, and more particularly at paragraph number 9, which have been already quoted herein above. Full stop. It is seen further, it is seen from the records that the affidavit, that the petitioner have filed affidavit in reply to the affidavit in opposition filed by the respondent number 2 and 4 on 30/5/2025, reiterating their stand, its petitioner's stand in the writ petition First, in the backdrop of the pleadings, let this court now take into account the respective submissions so made by the learned counsels appearing on behalf of the parties. Mr. Dida, the learned senior counsel appearing on behalf of the petitioner, submitted that the petitioner applied through proper channel and was issued a release order on 18th of September 2024 by the district and session judge, who is the appointing authority of the petitioner. He therefore submits that the appointing authority, that as the district and session judge was the appointing authority of the petitioner, as would appear where is that rules? Have a copy of the rules? I know it is annexed, but you have annexed wrongly. Otherwise, I would not have helped, asked you. Kindly see, Mr. Mohammed. Page 159. Look at it. And then while 159 is with the definition, and then page 160, rule 10 comes. Isn't it?
Yes.
Huh?
That is the complete. This is the complete rule.
Here 3 comes. Kindly see what you have enclosed.
In the writ petition, madam.
I don't know whoever has enclosed. 159 is his document. You have enclosed this in your writ petition rules?
My lord.
Huh?
Only the relevant portions have been enclosed.
He submitted that in terms with Rule 3.3 of the rules of 2013, the district and session judge of the district is the appointing authority of the petitioner. 4. The release order so passed, issued, was in accordance with law, and there was no necessity of obtaining any approval from the Guwahati High Court. He further submitted, oh, the rules of 2013 do not contain any specific provision for deputation But taking into account Rule 29, the laws, rules and orders which are time being applicable to members of the state civil services in the state of Arunachal Pradesh would apply insofar as the petitioner is concerned. He therefore submitted that in terms with the state, he submitted that in the state of Arunachal Pradesh, the central FR and SR is applicable. And in that regard, he referred to Section 5, Roman 5 of Appendix 5, which relates to deputation within India. The learned senior counsel therefore further submitted, drawing attention to the said Section 5, which relates to the standard terms of deputation, that in respect of non-gazetted government servants, the power of deputation may be exercised by the heads of the department and the petitioner being a non-gazetted officer, government servant, a non-gazetted officer, staff, non-gazetted officer, the district and session judge, who is the head of the establishment wherein the petitioner works, would have the power to send the petitioner on deputation to any other department of the state or any other authority, autonomous. Who is this? You are sending him to where? That I know. What is that? Or to any other autonomous body of the state of Arunachal Pradesh. The legal counsel therefore submitted that the district judge, concerned district judge who issued the release order dated 18/9/2024, had therefore justified the release order as would be seen from his reply dated 27/9/2024. The learned counsel further senior counsel further submitted that the Guwahati High Court, though have filed an affidavit stating that the resolution so adopted in respect to the principal seat shall apply to the district judiciaries. But there being no specific instruction in that regard issued. The district judge was not in error in issuance of the release order dated 18/9/2024. The learned counsel further, senior counsel further submitted that the revocation of the order, the revocation of the release order by the impugned order dated 27/11/2024. 28/11/2024 was not at all justified, taking into account that after the petitioner had joined her services with the respondent number 5, and almost for 2 months, the revocation order has been issued, that too without notice to the petitioner. He therefore submitted that the revocation of the order the impugned order of revocation the learned counsel, senior counsel further submitted that the revocation of the impugned order of revocation was issued on the dictates of the Guwahati High Court. That too without providing, without affording any opportunity of hearing to the petitioner, whose rights have been affected, for which this court not only should interfere with the impugned order of revocation on the ground of violation of the principles of natural justice, but also on the ground of malice in law. First, the learned counsel for the petitioner referred to which other judgments? the judgment of the Supreme Court in the case of State of West Bengal and another versus Nipendranath Bakshi. Are you referring to this?
Yes, my lord, 1968.
You're referring, no?
Yes, ma'am.
Reported in 1966 SC 447. Semicolon. As well as R.M. Gurjar and another versus the High Court of Gujarat and others reported in 1992 4 SCC 10 on the aspect pertaining to Article 235 and 236 of the Constitution of India and submitted that though the High Court has the control over the subordinate judiciary, but the High Court having allowed the rules of 2013 to be made, thereby empowering the district judge insofar as and thereby making the thereby permitting the district and session judge of the district to be the appointing authority insofar as the post held by the petitioner, that is the post of Pescar, there is a what?
Come on. The judgments which we are like,
Now, there is a what? There is a presumed delegation
there is a
delegation of power upon the district and session judge to release any stuff to release the petitioner The London Senior Council further submitted that as the impugned order of revocation is bad in law, the petitioner bad in law, comma, the deputation of the petitioner to the respondent number 5 therefore is in accordance with law. Referring to Rule 20 of the CCS bracket CCA rules 1965, the Learned Council therefore submitted that as the deputation is valid in law, is valid, comma, it is only the borrowing department, that is the respondent number 5, who have the jurisdiction to carry out any disciplinary action and not the parent department. On the aspect of principles of natural justice, violation of the principles of natural justice. The learned counsel, senior counsel, have referred to the judgment of the Supreme Court in the case of D.K. Yadav versus JMA Industries, reported in 1993, 3 SCC 259, and Sahara India bracket firm Lucknow versus Commissioner of Income Tax Central, there's I and another, reported in 2008, 14 SCC 151. Anything else?
My lord, there is one other judgment which we'd like to rely, my lord. Been instructed to rely 2020 19 SCC 480.
What is that?
My lord, since your lordship is saying that which was not done regarding the concurrence of the Guwahati High Court, Honorable Guwahati High Court, as regard to that, at
Oh.
most it can be termed as an irregularity which can be regularized. And in this point, my lord, if your lordship sees,
Wait. The learned senior counsel further submitted that even if it is assumed that the High Court had the jurisdiction and not the district and session judge to allow the petitioner to go on deputation, then also what has happened is only a case of irregularity, which can very well be regularized by post facto concurrence. And in that regard, refer to the judgment of the Supreme Court in the case of Siraj Ahmad versus State of Uttar Pradesh and another. Anything more? Oh. Mr. E.J. Mohanto, the learned senior counsel, appearing on behalf of the Guwahati High Court, submitted that what the petitioner is submitted if allowed, would impact the powers of the High Court conferred under Article 2 to 7 of the Constitution, as well as under 235 and 236 of the Constitution. The learned senior counsel appearing on behalf of the Guwahati High Court submitted that the Constitution have specifically delineated the powers which have been conferred upon the executive, the legislature, as well as the judiciary. As it is a bulwark of a constitutional democracy. First, the doctrine of separation of powers and the need for having an independent judiciary is not only the ethos of the Constitution, but is also apparent from a reading of Article 50 of the Constitution of India. First, Chapter 6 of the Constitution deals with the district judiciary and the provisions have been so made to achieve the avowed object of insulating even the district judiciary from the influence of the executive and the legislature. He therefore submitted that a reading of Article 235 of the Constitution would show that power has been vested in the High Court. The control over the district courts and the courts subordinate thereto. Referring to Article 236, the senior counsel submitted that the same control which is mandated under Article 235 would also apply to the ministerial staff of the district judiciary. First, the learned senior counsel submitted that the word control were used by the Supreme Court in the Article 235 have been dealt with by the Supreme Court from time to time to mean that it has been used in a comprehensive sense and includes the control and superintendence of the High Court over the district judiciary and the persons manning them, both on the judicial and the administrative side. First, the learned counsel submitted that this control so conferred by the Constitution upon the High Court would stand negated if the proposition so submitted by the learned senior counsel appearing on behalf of the petitioner is accepted, the learned senior counsel submitted, that if the submissions are made by the petitioner's counsels petitioner's the senior counsel for the petitioner is to be accepted, then the High Court would have no power of control over the district judiciary, both on the judicial side as well as the ministerial and administrative side and ministerial side. And the respondents and the district judges on its own transfer release any officer or staff working under its establishment. This would result in a chaos for which this court ought to dismiss the instant petition. First, anything else?
Yes, ma'am. So regarding this principle of self-justice, my lord, not known, because that was also submission made, my lord. There is not a pleadings in the petition. My lord, regarding that is a when order itself is known as, my lord, order passed by the authority.
The learned senior counsel submitted that the submissions so made by the learned the submissions so made by the learned counsel appearing on behalf, senior counsel appearing on behalf of the petitioner on the question of violation of the principles of natural justice is not a pleaded case of the petitioner. Be that as it may, the learned counsel further submitted that on one hand, the learned counsel, senior counsel appearing on behalf of the petitioner had submitted, questioned the very jurisdiction of the High Court to grant jurisdiction of the High Court under Article 235, thereby challenging the revocation order 235, the control of the High Court under 235, and have made various submissions in that regard. And that and thereupon have made submissions on the principles of natural justice. Violation of the principles of natural justice. He therefore submitted that when the petitioner herein have challenged the action on the part of the respondent authorities on merits, the question of approaching this court to challenge, approaching this court and the question of going into the question of violation of the principles of natural justice, alleging grounds of natural justice, violation of principle that does not arise. The learned senior counsel further submitted that the law is well settled. That law is well settled to the effect that there are exceptions to the principles of natural justice. And one of such is if it would result, if one of such is the doctrine of useless formality. The learned senior counsel submitted that this is a specific case where the very release order was non-est, and as such, there would be no useful purpose of permitting, of giving any notice before issuance of, before revocation of the release order. He further submitted that insofar as the disciplinary proceedings are concerned, the petitioner has been afforded all permissible have been afforded due opportunities. Anything more? In that regard, he has referred to the judgment of the Supreme Court in the case of Aligarh Muslim University versus so-and-so, reported in 2007 HCC 763. Mr. S.R. Abad, the learned counsel appearing on behalf of the respondent number 5, supported the case of the petitioner. He submitted that the initiation of the departmental proceedings against the petitioner was non-est, taking into account that the petitioner is under deputation with the respondent number 5. The learned counsel further submitted, referring to the office memorandum dated 17/6/2010, isn't it? 17. And submitted that without a notice of 3 months, the respondents could not have without a notice of 3 months, the question of recalling the petitioner does not arise. Additionally, the learned counsel also submitted that the respondent number 5 had spent hours in training the petitioner after she had joined. And in that regard, have also sent the petitioner to Delhi to attend a in-room training of in the National Human Rights Commission. Let us not use it. It is for benefit of the more benefit of the petitioner. He therefore submitted that the entire action of the respondent, of he therefore submitted that the revocation of the petitioner's, the revocation of the release order is required to be interfered with. Anything else? These were the 3-4 submissions you made. Huh? Suspension. No, that I've already stated, no? Because he had no role. I stated first that your person concerned, once he is on deputation, suspension or anything does not arise. Not only suspension, any disciplinary proceedings cannot be initiated. When he is working with you, where is the question of that? That is yours. Yes.
Hello, I'm sorry to interrupt. Hello, one more judgment we'd like to rely. 2007 9 ECC 539 regarding, since there was no rule, in absence of any rule, how this court has to,
Huh?
absence of any rule.
The learned counsel further submitted for the petitioner also submitted report likhi diba, that in absence of any rule, comma, rule, what is that?
Rules or regulations guiding deputation.
Then
So under such circumstances, the Honorable Supreme Court has stated that it is the controlling authority which will, it is the inherent power of the employer who will,
you are the employer.
no, my lord,
He's the employer. How?
not
Is-
the employer, my lord, the district and session judge. The district and session judge,
He's the employer.
not the employer directly, my lord, but he's the appointing authority.
Huh?
Appointing authority, my lord.
Does it say the appointing authority?
It says, my lord, since the corporation of.
Mr. Counsel, first of all, you want your senior to come, I can say it on his face. When you submit a judgment which has a relevance. Don't be, means if you submit a judgment like this, I can. But I'll have to comment out there. A senior counsel, he doesn't know hair or tail about the law. Hello, should I put it? You want, I can put it. The counsel appeared, the senior counsel appearing on behalf of the petitioner further submitted that in absence of any rules or regulations, comma, the district and session judge has being the appointing authority, has the authority to send the petitioner on deputation. And in that regard, referred to the judgment of the Supreme Court in the case of two thousand seven 9 SCC 539. Okay, I'll give the remaining judgment. We'll get it dismissed. But in this respect to this judgment, I will comment that the senior counsel doesn't know head or tail about law. It's shameful when you deliver judgment. Have you seen the facts?
My lord.
What is the facts? Tell me.
My lord,
Without seeing that, tell me what is the
it's
facts?
a deputation on transfer. My lord.
No. It is a case where these people in Durdarshan and Akashbani are central government employees. These people were after Prasar Bharati Corporation came, they were working in that corporation. They continue. Then Prasar Bharati wanted to transfer them. When they wanted to transfer them, these people challenged it, saying that, you see, we are central government employees, we are not the employees of the corporation. Then the question arose as to whether they can transfer or not. Then the Supreme Court held that there was a deemed deputation on the part of the central government with these people. And therefore, in transfer being an incidence of service, it was given. This is what the law is. But you have what to say. Judgments are placed like in. Anyways, dismissed. Your petition is dismissed. But I am going to say
My lord,
that the High Court has been very negligent on not taking any action against the year.
But-
And I hope what the word is, that is the word I'll use. The High Court becomes more, rises up to the occasion of taking steps against this district judge. And if not taken, then
and
what
that's
to
why
do?
my lord, till today not taken. As of now, it is not taken.
No, I will say, because with that,
Maybe
if
he-
no steps have been taken
Maybe he
against him, it is absolutely, not against him also, against the CGM.
They won't.
The reason why I have incorporated in my first part of the order that the CGM provided these documents, ACR. All these documents, the CGM had no business to give it. He could not have given, she couldn't have given that those documents without the concurrence of the High Court. You couldn't have given
Yes.
that. This is a very serious
Maybe he has
infraction.
confidence.
These are confidential. Tomorrow an ACR, can you give it
Can
to
be-
anybody?
Cannot be, my lord.
Under no circumstances an APR. So this, I'll therefore comment on that and say
And
that
even here,
I hope the High Court rises up to the occasion on the administrative side. Not the Chief Justice, the High Court.
full. High Court means 216.
Huh?
216. High Court means.
No, High Court will be under 366-14,
Right.
Article 366-14. So the High Court wakes up to the occasion and does something.
Item 15 fixed at 2 p.m.
So that
Yes, I have seen that, the minutes of the proceedings, it was on 16 December 2015. And I have also went through the judgment 1724 2015. So far as my understanding is concerned, Lordship, the subject of principalship pay is wholly regulated by the notification of 2016 only. And in my understanding, Lordship, that notification is quite clear, no ambiguity is there. And that has been also explained. Explained means in judgment dated 17/24/2015 by my Lord Justice Where Lordship in paragraph 14, if Lordship, it starts from page 14. Paragraph 14, Lordship.
6/4/2017.
1724 2015.
Order dated.
Lordship.
Order dated.
This is order dated 6/4/2017.
Paragraph.
The one paragraph, Lordship, I am relying. Sixteen. It starts from paragraph 14. I am at 16.
Paragraph 15.
Yes, 16, 1/6.
Yes.
Following the aforesaid order of this court, a notification dated 16/8/2016 was issued by the Judicial Department, Government of Assam, providing the principalship pay to the officers of the staff of the Guwahati High Court principalship, in addition to their existing pay and allowances to be given notional effect
from 1/1/2006 and arrears with effect from 1/4/2008. It was clarified that principal seat pay would be in addition to the respective pay of the officers and staff in the pay band and grade pay for determining basic pay. In other words, the basic pay would include pay in the pay band plus grade pay plus principal seat pay. It was clarified by the government that dearness allowance, house rent allowance, pension, etc. would be paid on the basic pay arrived at in the aforesaid manner. Next paragraph, Lordship. It has been submitted that the aforesaid proposal for the grant of principal seat pay by notification dated 16/8/2016 was accepted by the Guwahati High Court, whereafter officers, so and so on. So it was basically a proposal by the government of Assam, Lordship, state government, and that was accepted by the Guwahati High Court.
Then,
So that is exactly, Lordship, my understanding, Lordship. It is my humble understanding. So that is one, Lordship. Thirdly, Lordship, there is nothing on record to show that all the employees of the High Court are getting this benefit as has been claimed by the petitioners.
only the copies are getting.
They are getting. They are getting. I'm also coming to that point, Lordship. Only the copies are getting. So the on instruction, Lordship, I'm submitting. Government is ready to reconsider, re-examine the case of the petitioner's Lordship, just like the case of the copyist Lordship. So if the matter is remanded back to the government Lordship department. if
No,
positive-
no, no. You come up with a decision next week with similar type of them that you are going to reconsider and give it to them. I will allow it. Otherwise, no. Otherwise, you see, this needs to be brought to rest. Because everybody is getting it.
So far as this particular batch Lordship, 16 to 17.
Mr. Nayak, you see, these are things which needs to be earlier, if that judgment would have been more clarified to that effect, because otherwise, this led to a contempt. You came up, you made the submission that the government is going to look into it, the government is agreeable to that thing, and accordingly, the court passed that order.
No, in that case, Lordship, the exact word was calculational error or something like that.
Understood.
Lord.
Whatever may be.
On that
you,
point,
no, no,
Lordship,
you said that and the court had passed that order to
No,
that effect.
basic prayer was for condonation of delay period, Lordship. And over and above that, Lordship, if any calculation error is there, department is ready to consider that, Lordship. Same prayer I'm making here, Lordship. If any calculation error is there, as it has been raised, Lordship, we are ready to re-examine.
It needs to be brought.
That same direction, Lordship, pass in the case of the copyist. Lordship.
Finally come to page 141 or that judgment of Justice Shyam. You have that? It is there with the reply. Huh? Yes. Give him. You've got it?
Yes,
Finally
Lord.
come to paragraph 4.
Paragraph 7. Lordship.
4.
The 4 I read, Lordship.
What was the issue there?
It
Paragraph 3.
Paragraph 3. Lordship.
The facts of the case lie in a narrow campus and
Narrow
can be.
campus and can be noticed as follow. The writ petitioners are all working computer assistants in the principal seat of the Guwahati High Court as per the relevant service rules. The petitioners are employees of principal seat of Guwahati High Court. By notification dated so and so, the government of Assam had earlier approved the proposal for the aforesaid notification has clearly mentioned that PSP shall be admissible to all the officers and staff of the principal seat of the Guwahati High Court in addition to their pay band and grade pay, meaning thereby that the basic pay of the employees under ROP rules had to be treated as pay in the pay band plus grade pay plus PSP. Accordingly, the officers of the and other staff of the principal seat of the Guwahati High Court have already been extended the benefit of revised pay scale. However, in case of the computer assistant, department had calculated the revised pay scale only on the basis of the pay in the pay band plus grade pay, by excluding PSP, as a result of which this was a submission, Lordship.
No, that is the case of the petitioner. I'm therefore coming, this is the case of the petitioner.
Yes.
It is not that there is some calculation. You therefore see, you read this and then read paragraph 4. However, in the case of the year, the department has calculated the revised pay scale only on the basis of the pay in the pay band plus grade pay by excluding the PSP, as a result of which they are drawing lesser salary. The apparent reason for not doing so is on account of the fact that the writ petitioner, although were appointed prior to the notification of the ROP to year, but their appointments are after the notification dated so and so had been issued by the government of Assam approving the payment of PSP. It would be pertinent to mention that in the report, the petitioner have inter alia prayed for issuance of a direction to fix the salary under the revised ROP with effect from so and so. Then kindly, it appears that taking note of the grievance expressed by the video pertaining to the erroneous fixation of pay scale, the joint so and so had earlier addressed a communication to the judicial department pointing out the pre-revised fixation of pay of the Iman ought to have been Iman and it becomes so and so. As a result, the revised pay of the computer assistant under ROB would be Iman, next higher would be table Iman, and it was further mentioned that the pay in respect of all the officers of EA has been fixed after adding PSP with the basic. That is, basic is equals to pay plus so and so as admissible under the government notification dated so and so. Accordingly, a request was made to the Judicial Department of the to rectify the above computational error and refix the pay of the petitioner. So this is the context.
That direction only, Lordship, I'm seeking.
No, therefore, this is the context.
Lordship.
However, notwithstanding that the aforesaid no action has been taken by the department, judicial primarily on the ground that a finance was required in that regard. It appears that some other issues raised in have already been resolved during the pendency of the reserve, but the contentious issue that still remains to be resolved at this point of time is on the question of refixation of the basic pay of the petitioner after taking into account the pay in the payer so and so. Taking note of the facts on so and so, this court had passed an order directing the learned to obtain necessary instruction as to the claim of the petitioner. Today, when Mr. So and so had examly submitted, the finance would have no objection if the necessary computational error is rectified by the judicial, and in that regard, if any further clarity, the finance is ready and willing to provide. So this is what has happened. So therefore, this was the issue, specific issue. And here also, if you see, I am not saying from anything on the records. It is the specific case also of the computer copyist also that everybody is getting, except these persons who were appointed post 16/8/2016.
Yes, 16 to 2007, that period.
16/8/2016,
Yes.
after that notification.
Yes, from giving effect to that, no, those Lordship who in between got appointment from the date of giving effect of the ROP and date of publication.
Understood? No, that is one aspect. There may be some who are appointed in March because you gave it from 1/4/2016.
Lord.
Somebody may have been appointed in June. There is no problem with that. But those who have been appointed in the month of September is the issue. All these, the petitioners in these cases, as well as the copyists, were all appointed after 16/8/2016 notification.
Lordship.
So that is the issue why the question before is that these people were only taken out, not others. So
Lordship-
this is,
Lordship will pass the same order, Lordship authority, if any, just in this case of computer assistance, Lordship, if any, Lordship department will definitely pass an order, necessary order. So that is what department instructed me. And they realize that for this group of people, Lordship, this anomaly remain.
Hmm?
This anomaly remain in case of this particular group, Lordship.
only this. Those people who were appointed after 16/8/2016.
Yeah.
The petitioners, these three are there, and others were, and those copists. And most of the others came later on, so that is what.
Similar.
So what do you want?
Lordship will pass an order, Lordship. Ultimately,
I
Lordship will remand
would-
the matter back to the, because where I am submitting Lordship and insisting your Lordship, let the department take a decision on this issue, Lordship. Lordship, that will be easier for them also, Lordship. They will get one handle, Lordship, to take up the issue again.
I do one thing. No, handle is there because the order is already there. This type of order is
Because
already.
in case of them, Lordship, and even after this petitioner, Lordship, one more person will remain. That is also before the authority. I don't know who is the person. One
Who is there?
One more person is there. They have not named the person. So other than the petitioners, one more person is there.
Okay, I'll pass the order.
So let the matter remand back to the department.
No, I'll direct the finance to look into this. I'll pass the order. and,
Re-examine and pass an order, appropriate order.
Huh?
Re-examine the matter?
No re-examination.
No, that only.
No re-exam. Mr. Nayak, I am not going to allow them to again get the assistance of him. He's of no help.
No, it will not happen, Lordship. I assure your Lordship, of the record, Lordship, but it will not happen.
I would make it very clear because I don't want the contempt later. I'll make it very clear. Anyways, I'll pass the order. Writing judgments in bench one, one gets something to write here. The other judgment, I kept it out there to be written out there. That is also very nice. Don't get normally opportunities out there. I'll make it savvy. Order will be similar. Don't worry. That order will be similar. But should I incorporate that you will are ready to go for that computational error
Yeah.
correction?
No, I want to keep myself limited to that point only.
No, therefore, that is the only point here.
Yes.
But are you giving the same type of submission which is made before Justice Shyam? I'm honestly asking you that.
Not, no, but so far as first prayer is concerned, that condemnation.
No, that has been
was
done.
already
No,
been
no,
done.
as regard the
Only
second.
second part, Lordship, according to the.
No,
it is
therefore,
the-
there also, what you see, the Justice Shyam categorically also takes note of that during the pendency, certain issues have been already resolved, which was the 3%. Same here,
Yes.
3% has been resolved. What was not resolved was only this. And that was a computational error which requires to be corrected. Now, are you making the same submission which you made in before Justice Shyam?
Lordship, in fact, Lordship, in that case, these submissions never arose, this issue never arose. Although my Lord Justice preferred to write those submissions, Lordship, this was never there. Nobody, I mean, made those submissions.
Huh? That is what has been recorded out there.
D. Buraguhai was appearing in that matter. D. Buraguhai was appearing, and for the present petitioners, also A. Somua was appearing. It was their case was that it is a calculation and an error. So please be rectified in
But
their,
you've seen that order.
yes, it is there. Most probably in the pleadings it was there, in the petition it is there. But submission was, that is why I never responded those, submissions. in that
So,
case.
do you have that same,
Lordship, what I'm.
if you are not giving, no problem, I'll pass
Lordship,
that order.
Even without going to those submissions, Lordship,
Hmm.
my limited submission will be there, saying it a calculational error, let it be remain as a calculation error, let the department re-examine and redone the calculation and pass an appropriate order. That much will suffice.
No, my only question to you is whether you repeat the same submission which you made before Justice Shyam. No. No, it's okay. No, Mr. Naik, it's not required. Because you see, you are going to make a submission as a counsel for the department. If you don't want, not necessary. I have no problem with that. It is a different thing. In that matter you have made, you may not make it here.
Lordship.
So it may not be, because that might have been a consensus. I don't record it. You don't need to make it. If you, but the only thing when I'm writing the judgment, should I mention that you have made it or not? You said no. It's okay. We don't think. I will put it that as what you have submitted as regards that it was never a part of it, and in fact a reading of the judgment of Justice Bhuya on 6/4/2017 also, as per you, does not include this.
That much
I'll maintain what your submission is as per you, and taking into account 6/8/2016, 16/8/2016, your reading of it is that these three components are only for the purpose of calculation of the other aspect, not that aspect.
Lordship.
I'll maintain it in that. Same.
Obliged.
Daily list item 1 to 5.
Yes, finance.
No, the approval has been given. Here is the approval. On 9/6. They've given certain observation to modify one or two clauses. Otherwise, they have given. On 9/6. The online one, from the directly from the screen, they gave a screenshot to me. On 9/6, it has been given very top. Finding submission, a department has no objection on the draft Assam District Code Employee Service Rule 2025, subject to the following conditions. Some 7 or 8 conditions is given. And probably the judicial department has already given. Has already forwarded it to the registry office announced.
So this will be done by the judicial department.
Judicial, yes, sorry.
I don't think the MSCP happens every 10 years.
No, it is
MSCP
a
is
scheme,
every
madam.
10 years.
So yes, so for the revised part, it will be every 10, along with the ROP it comes.
No, what do you mean? MSCP is every 10 years there is an.
Oh, yes, MSCP. First ballot is 10 years, next ballot 20 years. Nowadays is three MSCPs.
So there is 30 years.
Yes.
So a person who there works for 40 years, then he
By
will.
the time they retire. Okay.
Now, does it again have to come to the High Court?
No, money here. But if the particular draft was prepared by the honorable court registry, in that case it will have to be, because the judicial is always.
Same procedure, my lord, it has to be placed before the honorable chief justice. Because last time also, you also will remember, there was.
Yeah, what they are asking is, I think this thing has already been cleared. The
Look,
post
if I-
of the bench assistant.
Last occasion, you also will remember, similar type of, my lord, query was sent by, this Deputy
No,
Secretary
no,
of
no,
Government of
last
Assam,
time I will see,
then
the draft rules were prepared before the issuance of the demand, the payment of the pay scale or year in view of this so and so.
so that we clarified.
Now, we have duly clarified, as regards the stenographer, bench assistant, bench clerk, grade 1, grade 2. Bench assistant is where? Bench clerk, the bench C, the post of the demand. It is already there. Now, in the rules, they have made it like that.
These are only suggestions, my lord, say that
Lord,
we have
my-
given the NOC.
My lord, my submission
Just
is that, my
modify.
lord, on the last occasion, when the Deputy Secretary gave these queries, we clarified those queries.
Hmm.
Again, this query has come.
No, the query, my lord. Not the
No,
query.
whatever query, question, whatever may be the thing, again this has come. I expect only that much, that this should be the last one. Because this Deputy Secretary would have seen these things in the last, Lord, questionnaire
Wait,
itself.
wait, yeah. To the allowed, yeah.
Otherwise, this will go on, my
In
lord.
Schedule B of the draft of the classification of the post in column 3 of the table shall be reviewed. Further, in column 6, the pay scale shall be assigned. In group here, the services demand be deleted. To ensure group 1 demand, the post of the accountant demand shall be included in the pay scale of. Now, Mr. Das, kindly look into Rule 31, Rule 6, point number 6.
Point number 6 is,
What is Rule 22 earlier of the draft rules?
Rule 22. Pay and allowances, leave, pension and other matters.
Is okay, but I'm only asking on discipline. Discipline do they have the power?
No,
Now, where's the rules? Do you have, anybody has the draft rules?
and my lord, serial number 8 also, this should not form part of the rule, recruitment rule.
No, this is not form part of the rule, my lord. This is the
This is
condition
not a
given
part
to
of
the
the
NOC.
8 is not a part of it.
Yes.
Except as provided in the all matters pertaining to pay, leave, so and all other concerns shall be regulated by the revenue scheme by the government for the purpose of the employees of the environment recommended by the Safety Commission. Mr. Gogoi, my lord, there seems to be a problem. Shall be regulated by the government. Earlier it was, shall be regulated by general rules framed by the government. I think, is it okay?
Shall be regulated by the government for the employees of the district judiciary.
Earlier,
Or,
earlier what was there?
Yes.
Shall be regulated by the general rules framed by the government. Now it is, shall be regulated by the government for the employees of the district.
or as recommended by.
Or,
the
no,
Safety
or as
Commission,
recommended by,
and
no,
accepted
that,
by the government.
that also there,
It says that finally with concurrence of the
as
High Court.
recommended by the, for the employees of the, as recommended by the city commission. and accepted by the government from time to time with concurrence of it. Now here, what you have done is or but this thing, I think, has to be sent.
Yes,
Others may be there, but this needs to be sent.
yes. Look, my only thing is that, my lord,
This should be last.
no, these things were already there. You could have meticulously checked it, incorporated in the earlier one. That could have saved our time, my lord. We are
Now tell
making
me.
so much of effort.
No, Mr. Gogoi, tell me one thing.
My lord.
If these are, if these, what you have stated are said okay by the High Court, does it again have to go to the finance?
No, it says, my lord, very first line says, my lord, the finance establishment requires no objection on the draft so and so. Subject to the following, so modification and it will be published.
So there is no further
No.
requirement
No,
of
my lord, in fact, my lord, last page, my lord, this is the approval of the honorable finance minister.
which one?
My lord, they have also have a copy, my lord, the last line of that, my lord, screenshot. This has approval of finance, honorable finance minister, last line.
Look, a better copy I have.
Oh, you have got it?
It has been mailed to the registry, my lord.
Oh, good.
So the judicial,
Yes.
so the judicial. Last line.
Then why it is a, and also to grant approval in respect of condition number 8 for taking further necessary action from our end. What is this?
No, this is not our part. This is the judicial department who has taken.
Whoever you, whether
So
it
this
is
is the
judicial
approval,
or
whatever,
finance, my
no,
lord,
no, ultimately.
Actually, hold on. Whether it is judicial or finance or personnel or establishment.
No. Judicial department has to look into.
I understand.
Now here, in this document, this line is not there.
Yes,
In view of the above, you are requested to consider the matter and if found just and
Lordship will
proper to
see, my lord.
incorporate.
Inverted comma closes at, my lord, this is the approval of the honorable finance minister. This is the approval of the finance. This has been quoted in this letter. And the last para, in view of the above, you are kindly requested to so and so. This is the observation made by the judicial department.
Proper to incorporate the aforesaid conditions 1 to 7 in the draft remarking. Remaining, there's no problem. Only thing seems to be 6. So it has to be then again placed before the committee, rule-making committee. Hello, placed before the CPT. So we will record it.
Yes.
But this is the final,
Yes.
yes, sir.
the, what you call the, doesn't have anything.
Yes, that is the final.
And Mr. D. Nath comes up and says that in respect to this, they don't have anything more to say except this. So let it be then placed before the, I'll say that the rule-making committee has to be placed before that. And so that it will be. Yeah, I'm there in that committee also. Only remaining all are 18. Mr. B. Gogoi, the learned counsel appearing on behalf of the finance department of the government of Assam, submitted that the finance department has already given its concurrence to the draft Assam District Court Employees Service Rules 2025. However, subject to seven conditions. However, subject to however, subject to certain amendments sought for to the draft Assam District Court Employees Service Rules 2025. He submitted on instruction that if the conditions which have been mentioned in the approval of the finance department is duly taken note of, there would be no necessity of again reverting the proposal back to the finance department. The proposal, the finance department's sanction approval was placed before this court, which is kept on record and marked with the letter Z. Next one Z হয়েছে না? Mr. Dinar, the learned counsel, appearing on behalf of the Judicial Department of the Government of Assam, submitted that pursuant to the approval of the pursuant to the concurrence given by the Finance Department to the Assam District Court Employees Service Rules 2025, the said communication by the communication dated 10/6/2025, the Registrar General of the Guwahati High Court have been duly apprised and in that regard had submitted a communication which is kept on record as Z1. Why the finance department have not asked for this? Why you are asking for numbers condition 8?
In fact, it has been given by finance.
Understood. Finance gives this approval,
Yes, approval.
but where do you insert this?
Serial number 1 to 8.
These are the 7 conditions in the rules. You don't insert 8 anywhere.
Follow.
Who is going to give an undertaking?
But in fact, while giving the condition,
No,
finance.
that is your that is their condition.
That is the
That whatever may be, we are giving this subject to, this is their condition.
Follow.
But this condition cannot be a part of the rules. Isn't it, Mr. Gugoi? It cannot be a part of the rules. This will go as per that AFRBM, which is already there. This will go as per this. Only 1 to 7 can be there. This is the amendment they are seeking for. 8 will be on an administrative side, something will be written.
That has to be
But
taken.
it cannot be a part of that rule.
1 to 7 has to be incorporated and the 8 has to be taken care of while preparing if anything is done in future.
Now, this is
That is
because the finance is saying, which not, it's not the High Court or the district judiciary. It is for you. You are the judicial department. You are therefore you have the power under 309. Tomorrow, this notification will be issued under your aegis, not the High Court. So when you are issuing it, it will be your responsibility. How can the High Court say anything to the effect likely to cause expenditure of a sum from the state exchequer prior concurrence of the finance department? Government shall be taken in all cases. This is your duty. Am I wrong, Mr. Gogoi?
Yes.
Because the High Court cannot do that.
Cannot be in the service rules at least.
Neither it can be in the service rule, neither can the High Court give an undertaking.
If anything comes in the future, then that has to be processed.
That is your,
That is
no,
the
this is
different
the government, the finance department takes as a matter of abundant caution, says that whatever expenditure, so this is an approval with this condition. We are approving this as a condition, which will be there. But why you are asking by this communication and also to grant approval in respect to who is going to grant the approval?
In fact, in the last para, they said that requested to consider the matter and if found just and proper to incorporate the aforesaid condition 1 to 7 they have said in the draft rules, and also to grant approval in respect of, as Lordship has pointed out, that administratively, ultimately in the administrative side, whenever it is required, then the as per AFRBM is already there, as Lordship has pointed out.
Therefore, this is unnecessary, no?
It will not be a condition in the rules.
Understood, but who is going to give this?
In the administrative side, ultimately, they have
How
to-
can the High Court give this?
Because every proposal will have to be routed for the
Routed for the
judicial to the
judicial.
finance, so
That-
they will.
So
put the-
everything is already there. You see, this clause 8, condition 8, they put it. The reason is the finance says, all this, whatever you want to do, do. But whenever there is a question of spending money, it has to be routed to the finance. This is the subject matter of the condition, the concurrence. So tomorrow, this particular document which is there will always hold the field. Because this is the basis on which I gave you the concurrence. The rules cannot be made on this. So this approval question does not arise for condition 8. Because that is a part of the sanction and the approval. We put it in that manner. Because the High Court cannot give this approval. More particularly, the rule making committee cannot give. Mr. So-and-so, the learned counsel submitted that on 10th of June 2025, the Deputy Secretary to the Government of Assam Judicial Department have apprised the Registrar General about the concurrence given, about the approval of the concurrence given by the Finance Department. Again, you have written, has returned a file with following observation. What is wrong? Has not returned the file. Has no objection. You see the word. See Mr. Liaison. Finance Department has no objection on the Iman subject to the following conditions. Here it does not say that we are returning the file. Because the moment you are returning the file, means you have to again submit. about the approval of the concurrence of the finance department. Mr. Dinath, however, submits that from a reading of the communication, from the reading of the approval of the finance department as have been placed before this court, comma, the communication dated 10/6/2025 does not seem to be what the finance department had intended, except clauses 1 to 7 except what is quoted of the sanction,
Yes.
approval of the finance department in the communication dated 10/6/2025. Because this is a quoted.
Yes, yes.
Quoted.
Lordship can put it in the order.
Entire from reference to.
He therefore submitted that the Guwahati High Court in the administrative side has now to take a call as regards the conditions 1 to 7 as mentioned by the Finance Aid Department in their no objection. It has been also submitted that as regards the clause number 8, the Finance Department did not seek any insertion of that condition in the rules, draft rules. But what was intended was that any matter that is likely to cause expenditure of the sum from the state exchequer prior concurrence of the Finance Department, Government of Assam shall be taken in all cases. He further submitted that this condition as given in the financial sanction, in the sanction, so grant in the concurrence given by the Finance Department is for the judicial department of the Government of Assam to fulfill, which should be duly taken note of at the time when the draft rules are made. Mr. H.K. Das, the learned counsel, the said communication is kept on Z1. Z1 Anisuna. Mr. H.K. Das, the learned counsel, appearing on behalf of the Guwahati High Court, has submitted that the Registrar General of the Guwahati High Court has received this communication and the same would be duly placed before the necessary committee so that the same can be brought to a, can be completed at an early date. The necessary formalities can be completed at an early date. Pusto. List the matter on 26th of June 2025 for an update. You just put it then, I'll take it up on the administrative side.
Yes, yes.
I'll ask that register to tell me, so I'll ask them. Order to my ID. But what about the deputation aspect? I asked you, remember last time? I asked you on the question of deputation.
Yes, in the next matter.
Now, in this clause, in these rules,
Actually, my lord, both these queries, I remember, my lord, these two queries. My lord, this is one query with regard to deputation and another query is in the next case. My lord, both I was supposed to discuss with the RG. My lord, RG on the last few days
he has been ill.
he was not keeping well, so that's why, my lord, I could not sit
This is on
across
the accountant.
Yes, accountant one.
What do you have to say?
Next case, my lord.
Equivalency and
That equivalency, my lord, I could not sit across the table with the RG and come to a conclusion what is.
Because the High Court has to file.
Yes, my lord. Something has to come from the High
Because
Court.
they
My
have come
apology.
up with another aspect. They go on the question of equivalence. Mr. Sharma, you are there.
Yes, I mean the next.
I'm
Yes.
saying about the next case
Yes.
only. Mati,
6 and 7.
Direct to submit a report from the administrative side of the High Court, whether the accountant can be promoted.
So that is what I have asked them. No, the thing is, what is happening, the Registrar General is keeping unwell. He is on leave. That is
Yes,
the
sir.
reason why.
Yes.
That I know. I've seen it.
Some accommodation.
He's on leave. He's not well. But the thing is, the High Court has to file an affidavit
Yes,
in that regard.
There is no doubt.
And there has to be a clarity being given because accountant and this needs to be
That
done.
cannot be the principle that has been, my
Mhm.
lord, stated.
And because then tomorrow the Nazir will become.
Judicial Department has submitted affidavit
that judicial,
stating that the accountant.
that is not, I have placed it before the law.
Only on the pay scale.
The pay scale, because of the job responsibility and other things, judicial department cannot comment on that. This is for the honorable court.
But this is
Ultimately, that has to come from the honorable court.
accountant and UDSs are equal. They have submitted affidavit. Now let the report from come from the registry in administration side, whether it can be promoted or not, your lordship has directed them to file it.
Perhaps, my lord, this may also has to go before the recruitment committee subject because originally that decision, copies, typist and computer typist, that was also taken by a committee.
Which one?
The equivalence of copies, typist and computer typist, that decision was also taken by a recruitment committee of this honorable court. By virtue of that decision, my lord, 2 notifications were issued, which were challenged in the earlier series of cases, my lord. So perhaps this also has to go before a committee for a final decision. So lordship will give
No,
me slightly
let
longer
the-
time.
First, you may file an affidavit.
Your lordship is asked.
No, my lord, what I am saying is that the contents of the affidavit will come from perhaps from the recruitment committee because what?
Wherever it is, the Registrar General
Yes,
has
yes.
to know from there.
Yes.
He has to come up with some idea. I've given you lots of time.
My lord is correct.
I know that he is not well, so obviously I will excuse it, but that doesn't mean that, you'll place it before the recruitment body and all. That is not.
No. First of all, my lord, I'll
Question he has to put in a question somewhere, somehow.
No.
How it is to be done.
No, my
But
lord
he
is
has
correct.
to put the ball in motion.
Yes.
He has not done
Obviously.
so.
No, obviously, there is no doubt about it.
Then
So some
Mr.
longer term-
Mr. Deenat, the learned counsel, senior government advocate submits that the judicial department has filed an affidavit on the question of equivalence of the post of accountant and UDA. Mr. H.K. Das, the learned standing counsel of the Guwahati High Court, however, submits that the affidavit could not be filed on behalf of the Guwahati High Court on account of the absence of the Registrar General of the Guwahati High Court for his illness. He therefore submits some more time may be granted. Before vacation, after vacation?
Before vacation, my lord.
Before the
26th.
28.
28 is
Vacation.
closed.
26, my lord.
26 already fixed other cases. So next date it may be. Because I find it difficult, my lord, to went from 10 to 4 p.m. my lord. I'm feeling unwell. That is why answer that way it is. 26, 27, 28 hearing there.
No, let us get the affidavit, Mr. Sharma. Let us get the affidavit. We'll see then what happens. Let's see the affidavit on 26th. The affidavit, the Guwahati High Court shall file the affidavit as directed earlier.
Yes,
On or before, prior by 24th of June.
Item 8,
Much obliged. Milord, in item 8, the disciplinary authority has passed the order, Milord. This is the copy. In fact, the disciplinary authority, Milord, has dropped the charges. Exonerated. If, Milord, I have seen a fair decision, Milord. Because there was no material for misconduct, Milord. And the period was also regularized, has also been regularized as earned leave, Milord.
It has been submitted by Mr. Ichkedas, the learned counsel appearing on behalf of the petitioner, on behalf of the Guwahati High Court, that the disciplinary committee have already, the
Disciplinary authority.
disciplinary committee authority had passed an order dated 10/6/2025, whereby the petitioner have been exonerated by dropping the disciplinary proceedings against her and the leave so taken from 5/1/2025 to 18/4/2000 has been considered as earned leave. So in that regard, the report of the disciplinary committee has been placed before this court, which is kept on record and marked with the letter X. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, submits that in view of the decision taken by the disciplinary committee on 10/6/2025, nothing further remains for which the instant writ petition has become infructuous. He would not therefore press the petition. Accordingly, the instant writ petition stands closed on withdrawal.
Deeply.
9,
In this matter, Milord, they have filed an affidavit in opposition, Milord. I'd like to have one opportunity to file it now.
What? 2024, it has been filed and we are seeing now? Yes, government? Oh, you. What is this?
Milord, if your lordship will kindly see page number 18,
What are you challenging?
30% reservation, Milord, that matter. 30% female reservation. That
Female?
has not been complied with. Women reservation, Milord.
Then,
If your lordship kindly see the advertisement at page number 18. This is the advertisement, Milord. 12 post.
Lordship, I am appearing on behalf of Mr. Vijay Mohan, Lordship. Today we have missed this item, Lordship. Kindly matter will be taken about Tuesday, Lordship.
18, what is that?
18 is the advertisement.
Then,
My lord, they advertised 12 vacancies, my lord, 12 vacancies. Out of that, my lord, they kept 6 for unreserved, my lord. Page number 18.
what post are we are
Peon,
concerned?
peon, post of peon, my lord. So out of
Unreserved 6, MOAC, OBC, so and so.
Yes.
Yes, then,
So out of 6, my lord, they filled up only 5 posts. 1 they did not fill up. Now what they did was that by applying this 30% reservation, my lord, they selected 3 female candidates out of 5. So it is more than 30%, man. I am at number 2 in the waiting list. If your lordship will kindly see the selection, my lord, at page number 27.
appointed,
Appointment has been done.
no stay.
No.
Then, why should I interfere?
No, but during the pendency,
What?
no, during the pendency, my lord,
Huh.
if your lordship will kindly see.
You moved in the year 2024. When was the appointment order made?
Appointment was made perhaps in the year 24 itself, my lord.
Huh?
So,
Yeah, 23.
Page number 27. The
23. Then
my lord, during the pendency, my lord. Your lordship-
24 appointment.
Yes,
selected
your lordship will kindly
candidate.
see the results, my lord.
Reserved for women 3.
Yes,
Then
my lord, the person, candidate, who is
Ah.
in serial number 2,
Ah.
he resigned. He resigned, my lord, because he was overqualified.
Who?
And some, my lord, serial number 2.
ah,
And 2 female candidates, my lord, they also resigned because they were overqualified.
Jessima and Alima.
Yes, Aisha resigned, my lord. Aisha and Alima resigned.
Ah.
So I am at serial number 2, Monirul Islam.
Then
So even without challenging, my lord, I am entitled, my lord, if I am adjusted against if one of these vacancies, my lord.
you are adjusted against.
One of these vacancies, my lord.
That is your case.
No, that is the, my lord, subsequent development. My case was regarding, my lord, over selection in 30% category, my lord. That was my case.
But where is the question of waitlisting? No waitlisting business. This goes against the 2015 rules. Yes, Mr. Barbuzari. Doesn't it goes against the AFRPM? Section 7G. Huh? You are the main person with AFRPM. Mr. Barbuzari, that case you appeared, na? Sukhmone Day or something.
So for my day.
So there, the amount will be not 10 lakhs, it will be more than that.
Yes.
Why I'm saying is by virtue of an interim order, another 6 months was given.
Yes.
Remember? Because that amount was 10 lakhs sought for. So thereafter, there is another 4 months.
Yes.
He filed a petition. He said that my representation has not been taken into consideration, and therefore the court stayed and continued to pay what he was getting.
Yes.
So there will be more than that.
Because during that interim period, my lord, he was drawing that higher amount of pay,
Ah.
which otherwise he could not
So
have.
till the decision in the December 2013,
Yes.
he would be getting. 2014, he will be getting.
Okay. They even accept that only, my lord, that differential amount of which we had calculated 300 something amount, that will be deducted. That
So,
is
but
only
it
a,
will
my
be
lord,
more.
calculation area. Otherwise, on the principle of law, lordship has already dictated. Lordship was speaking about 7G.
7G. Because you do, now after this 7G, where is the question of waitlisting? Well, waiting list.
Perhaps. Because 7G says, notwithstanding any other provision contained in any act or rules, the select list prepared for the fresh appointments to vacant sanction posts shall contain the names equal to the number of vacant posts notified at the time of calling for applications for filling above the post. Now,
Waitlisting is not there.
administrative actions cannot go beyond the statute.
Now, you have, what is your challenge here? That day I passed a judgment also, bringing Mr. B. Gogoi somewhere. Isn't it, Mr. Gogoi? That day I got all of this and passed it. Huh?
Yes, Omar was there for the petition.
I pass the judgment. No. Because this, I've asked Mr. H.K. Das to ask these government officials to do the needful also.
Yes, sir.
Because that waiting list business has to stop. Huh?
That has gone, there's a Supreme Court judgment also I have placed, my lord, once recruitment process.
You refer to Surendra Soni.
Yes, my lord.
Now, Surendra Soni is one aspect,
Yes.
but apart from that, Surendra Soni still says
Yes.
that waitlisting candidate can be brought in, provided the person did not join after being selected, that person who can come in.
But this concept that once a recruitment process is over, after joining of the person, then the entire process,
That
And-
goes away.
if any post left comes up, then it is to fresh recruitment.
Challenging the air of the respond number 2. Who is respond number 2? Huh? Why you are challenging it?
My lord.
Why you are challenging it? Ground?
Ground, my lord, this 30%, my lord, reservation, my lord, they had applied. And what they done was that, my lord, out of 5 posts, my lord, they selected 3 candidates. So it will be over and above the 30%, my lord.
Then?
So one candidate goes, my lord.
Now, those 2 candidates have left.
Yes,
Then, matter is over. What remains in your case? Your entire thing is that set aside the entire select list.
yes,
Isn't it?
yes.
Now, what you want to do is that 2 seats are vacant. So let me jump into as I'm in the waitlisting category. Isn't it?
Yes, and one was not filled up also.
Maybe, but these are whatever maybe. It cannot happen. On one hand, your entire case is if you want the and setting aside of the entire thing. Now those 2 ladies being gone,
Yes,
so your ground of objection to the select list goes. Okay.
yes,
So if that goes, can you jump out there and say that look here now appoint me in the select list which I have said that it is bad? Tell me. Not possible. Chalo, one judgment on merit has to be there today.
but one opportunity, my lord,
What opportunity?
I'll file my review.
No, no. You have better things. You are a great civil lawyer. So try do all these things there and finish up this matter. Heard Mr. S. Das, the learned counsel appearing on behalf of the petitioner. You have any objection? Joins, no on behalf. Joins on behalf. Mr. T.R. Gogoi appears for the respond number 2 and 3. Huh? Respond number 1 and he appears for respond number 2 and 3. So stop. The petitioner herein have assailed the select list dated 1/2/2024 insofar as an appointment of the respondent number where is it? So far as the challenge the select list dated 1/2/2024 insofar as the appointment of the peon in the office of the respondent number 2. On the ground that while appointing, while making the said select list, the reservation of women has been more than 30%, isn't it?
Yes.
The petitioner also seeks for a direction upon the competent authorities to recommend the name of the petitioner for the post of the peon in the office of the respondent number 2. It is relevant to take note of that the petitioner herein have assailed the selection of three candidates to the unreserved post of the peon on the ground that there has been in excess of the woman's quota of 30%. But the petitioner have not cared to implead the said candidates.
I filed in IA, my lord, which I withdrawn.
Huh?
I filed in IA, my lord, for impleadment, but subsequently I had to withdraw because they had, by the time, they had already resigned, my lord.
You have withdrawn. So on this ground only dismissed. You should could not. But did not care to implead the said selected candidates, woman candidates. On this ground alone, the instant writ petition deserves to be dismissed. Be it as it may, it is relevant to take note of that out of the three woman candidates who were selected, to the unreserved quota to the post of peon, two have resigned. Resigned?
Resigned.
Resigned. In the meantime, Pusto. Under such circumstances, the select list so made, having one woman candidate as regards the post of the peon unreserved, as against 5 posts of peon unreserved, cannot be said to be bad as being violative of the woman's quota. The learned counsel appearing on behalf of the petitioner submitted that having as those woman candidates have resigned, the said posts be filled up from the waitlisted candidates wherein the petitioner was at serial number 1, 2. In the opinion of this court, that in select list, so prepared, the candidates joined, who were selected had joined, and thereupon had resigned, having joined, and who were selected, having already joined, the select list stood exhausted insofar as the post of the peon is concerned, the subsequent resignation leads to a creation of a post vacancy, which in the opinion of the court has to be filled up by following the due process. Under such circumstances, the question of issuance of a mandamus directing the respondent authorities to consider the case of the petitioner to be appointed against the vacant post which has arisen on account of the resignation of the candidates, of some of the resignation of the persons who had joined and resigned, does not arise, for which,
And my lord, there were 6 posts, my lord,
huh?
advertised. 6 advertised posts, my lord. Only 5 did filled up. 1 was left out.
Then also you don't get. One is already there. Accordingly, this court finds no merit in the instant petition, for which the instant petition stands dismissed. Full stop. Be that as it may, age is there, no age. The respondent authorities, be that as it may, the respondent authorities shall take appropriate steps for filling up the post, vacant post, at the earliest, and the petitioner. You want to participate? Do you have the age or not?
Yes, yes.
No. What is the age? 35?
35,
You were 35 in 2024.
24.
You are 36 today. 36, can you become a peon?
No, in the post,
then-
for the post of peon.
Fill up the post
Hello.
in accordance with. Yes, Mr. H.K. Das.
Confusion was with regard to, my lord, whether the private respondent, he applied as EWS or not. My lord, inadvertently, in the eligibility notification, her roll number was, my lord, shown under the column unreserved. But she applied as EWS. That record I have annexed with the affidavit. And she got selected as EWS woman. If your lordships kindly come to page 37,
Page 57.
37, my lord. Annexure 4, this was a notification,
Affidavit filed by whom?
affidavit filed.
Terin Mosamat
That is a private
Hakim.
number 5, my lord.
Hakikatun. You are.
Affidavit has been filed within, my lord, the EWS certificate of the private respondent. I have annexed, that was prior to the last date of the application.
Your affidavit is where?
My affidavit is dated, my lord.
Copy of the
page
application
60,
along with
running page
EWS
60.
certificate. Let us see his application.
His affidavit is at running page 48, my lord.
No. This one, Annexure A1, is the application of that lady.
Yes, my lord. So she applied as a EWS, my lord.
Where?
Lordship will find,
Yeah, EDUS obligate. Whether there is any government, semi-government, so and so like relationship, name of the job, so and so. Family income from so and so. Where is that here that I am applying?
next page, my lord, page 62.
62.
Yes,
This is okay,
certificate.
but in the form, where is it mentioned that I am
Just,
applying?
I'll just indicate.
Uta?
Family income certificate, EWS certificate enclosed.
Are you a member of the scheduled caste, scheduled tribe? Yes, no. If yes, give particulars. Age on so and so. Present occupation nil. Present demand is nil. Are you in occupation? No. so and
17,
so, employment, registration number, so and so, family income certificate, so and so, where is it? Eh? You have brought the records?
Sorry, my lord. No,
Records.
records I have, it's not there with me, my lord.
Huh?
Only this affidavit.
No, no. We will see the records of other,
Yes, yes.
because he was EWS. Did he apply as EWS? That is the question.
I'll get the record.
That is, and another thing, my lord, in respect of the women reservation is concerned, they have subsequently said that because the respondent number 5 got the less mark than me.
Hmm?
Got less mark than me
Hmm.
in the written as well as the Viva test. And 3 posts has been advertised. In the advertisements, nowhere mentioned that female reservation is there, women reservation. Be that as it may, my lord, the women reservation, as per the women reservation rules, my lord, the reservation should be horizontal.
Huh?
So, horizontal women reservation. That is one post for unreserved category, one post for HC, ST, one post for OBC and MOBC, and one post for EW. 3 posts is there. So whether against the single post, the women reservation would apply on that. That is also the question.
No, that matter where Mr. Ponmojyoti Monto is appearing, another matter, na? I'm dealing it. Which case? Which? It was? Huh?
Fixed on July.
Ah. Not 24, 24/7. That is another case, na?
Yes, yes, that they.
Where I have asked
Lordship was-
for the total, because I've looked into the rules.
Yes, sir.
The rule says in the establishment.
Yes.
In the establishment, there has to be, if there are 100 posts, then how many it will be? And in the rule categorically,
Given the yes.
it is given, isn't it?
Yes.
Hello.
That chart given in the rule, that is for reference only. My lord, I have also checked up.
No, not on that, but rule 4.
Rule 4 is very clear.
My lord, what my friend is saying, that this 30% reservation will be on the cadre strength.
Yes.
But the law is this 30% women reservation, which is
No, no, it doesn't say, he cannot say cadre state.
No,
It
he
has
is
to be
saying,
in the establishment.
Establishment.
I
yes.
understand, my lord. Finally, lordship will refer to the chart, or lordship want to see what was the cadre strength, because rule, my lord, that day I was also there, my lord, lordship raised the query. Because rule 4 says that on the commencement coming of this act, the post has to be ascertained, so that lordships wanted to see what was the total cadre strength of the establishment, and how many posts were earmarked for women out of that.
Because what is happening,
Because in
may
the rule,
tomorrow, this came in 2015,
Yes.
isn't it?
Yes.
So once it has come in 2015, so you may not have that. The 30%.
2005.
So,
2005,
2005, but you may not have the 30%. So therefore, it has been given, it may be like a roster system,
Yes.
roster points.
Yes.
No,
So-
my lord. Perhaps, Lord, I'll just explain. Lord, the chart which has been, or my lord, the last page of the schedule that was given in the rules, that is an advice given to an appointing authority having 100-point roster, that how the women reservation will play in the cadre strength. That is an advice. That if there are 51 posts for UR, then 16 will be earmarked for women. But how to fill up? It has to be on the basis of vacancy. Say for,
Definitely.
yes,
So
definitely.
therefore, prior to that, rule 4 say, so before the advertisement you are doing it, you have to categorically come in. Yes, this is a post which we are earmarking for the woman.
Even if perhaps for any reason that is not done, things.
Then you have to fill up somewhere else later on.
So vacancy wise, say for example, I have 10 vacancy today. So I want to fill up. So 30% of the 10 vacancy.
No,
One second, madam.
Yes,
If you have 10 vacancies in the general, if you have 10 vacancies, of which in the cadre, there are 20.
Yes, ma'am. Yes,
And in that cadre of 20, you are having 10 vacancies.
you are.
10 vacancies. So which means 20, 30% would be 6. 6
yes.
or 6.5. If you want to go for an exact thing, isn't it? 6 3 is 18. So it will be 6 or 7. Now, 7, you already have 4 in the 20. In the earlier 10, you have already 4. Then you have only to 3. Although these are 10, you have to only fill up 3. Or if you have 5, you have to fill up only 2. You can go beyond that. It's a different thing if somebody gets it. But the question is, you cannot have a reservation. And when you have a reservation, you have to specify in your advertisement. Without specifying in the advertisement, that means you cannot say that, okay, for that woman, I'm bringing him here.
Yes.
You cannot do that.
No, here it was reserved for EWS. Here, it was reserved for EWS.
EWS, I'm not concerned.
Hmm.
I'm saying about a woman. If it is a woman quota concern, it has to be specific, very specific. That if you have 20, that is why you have to have 30% in that cadre. Because you see, the basic idea behind the women's reservation is that this is a parliamentary bill. Is that there should be in every establishment, there should be 30% women at least.
Yes.
Absolutely, yes.
So therefore, how you have it is different. But you
I am
may,
on how.
huh?
I am on how.
No,
Yes.
how you have it is different.
Correct.
I'm not on that. But the
Correct.
question is, you should have 30.
Yes,
But
yes,
you
yes.
may not have. Just for example, all the 10, out of the 10, out of the 20, 10 are all men. Okay.
Hmm.
So here, the next 10, if you are filling up, has to be 7 is for women.
Well,
You cannot say that vacancies here, I'm only going to fill up by this. Then only you can maintain. But taking into account this may take some time, that you may not get some woman candidate. Then how do you take care?
The rule is-
Therefore, I say, in the time of a roster point, somehow you have to maintain.
Ultimately, roster, the total cadre strength will come into play.
The
There is
one
no
day will
doubt
come
about
in,
it.
but this is how you have to do it. Because you see, the roster points have developed sometime around in 79, 71, 75.
Yes.
This is how the roster points develop. Because initially there was nothing. They thought, okay, this point, this amount will come in.
Roster
people
point
leave it.
basically a scale to measure that.
When you have more and more establishment you require, because to have it easier, that how do you fill up? That tomorrow, okay, this is not done, so okay, next time, we are going to fill up too.
Exactly.
But in the advertisement, you have to be clear that, okay, for women, we are taking this. And you cannot, for one reason, okay, for women, we are giving him this time, this time.
Another question will I put myself.
Put so many. One question is
I'll
enough.
try. In this
the
matter
rules-
also, Milord,
in
I'll.
the rules, my lord, the category was given, suppose, as my learned friend has said, that 30% from the total vacancy. If 30% from the total vacancy, suppose in unreserved 100 of vacancies, the 30 will be from women. So in unreserved category, suppose 40 has been.
No, there were 3 posts.
Yes, 3%.
One is
So my
reserved,
friend is saying you have to calculate
unreserved,
30% of
MOBC
one.
and UDB.
Yes.
My
UW.
friend is saying.
Your question is that you applied as UWS.
Yes.
So the question therefore arises is whether any application form there is a permissible thing to apply as a UWS. That is the most important thing.
Yes.
So because in their application they have only enclosed, because their application format does not show how you apply as a UWS. That is what I was looking into. If you see this particular document at page 61,
Perhaps it was implied. Once you
enclose your UW certificate along with the application, if perhaps that was implied that
One has to be clear.
my lord, applied as a UWS candidate.
But some discrepancies also found, my lord, in the certificate of
But
it.
the argument advanced by the petitioner that since there are three different categories of posts, UR, MOBC and EWS, now 30% has to be from one, 30% of another one and 30% of the other one. That cannot be.
That,
30% of the three.
Women doesn't have a, no, there cannot be even a 30% of the three also.
Yes.
How can you have, when we are having one post, more particularly when the rules categorically say that it has to be in respect to that particular post. The general has to be 51 and against that it should be 16.
16 years.
So therefore, if you have to do it, you have to challenge the advertisement for not being given a woman reservation, but having participated, then you cannot raise. Anyway, I am not here to advise. Hello. So you produce the records.
I'll produce the record. My lord. Along with that writ petition, my lord, with the
24th,
24th of July, fine.
this is the matter again on 24th, on which date Mr. H.K. Das. I have already passed the order for production of records.
Oh, I'm so sorry.
They have to shall produce the records on the next.
24/7, my lord.
No, 24/7, huh?
Yeah,
Where's that lady? 24/7.
24/7.
24/7.
Fine, obliged.
Any more? No more. Why all finance councils are waiting? These are councils very difficult to find.
Perhaps maybe because of
Item
440.
11 was there, madam. Let it-
Which one?
But there is a proposal that we have received from 6/6
Ah.
from the judicial department now regarding payment of arrear salary to one man employee who was re-engaged after the.
Oh, yes.
People.
A. Bhattaji. Your A. Bhattaji's case. Okay, let me take up that matter and finish up the others.
11.
It will. Others may go. We'll finish up that. What is the item number?
11.
Sir, we have received it on 6/6. We pay for some time. madam. Will it be on Thursday next, not 19, madam? No, not 19, madam. Let it be on 26.
Huh? They had the money. You did not allow this money to be used.
Let it be on.
Where's that proposal?
No, madam. Proposal we have received, I got a telephonic instruction that on 6/6, my lord, it has been, my lord, forwarded to the finance department. Then we pray for, my lord, 2 weeks time to examine the same, madam.
You have already rejected many times.
No, my lord, there was some query raised, my lord. Now it has been resubmitted on 6/6. Last week. By the judicial department. So, my lord, before the vacation, let it be on 26th. At least I will place the status on 26th or immediately after.
List the matter again on 26/6/2025. To start taking into account the submission made by Mr.
My lord,
B. Gogoi that the proposal have been received on 6/6/2025. For an update.
Can it be on the first Thursday after the holiday? Miller? If I may
You are not there.
have some problem on the 26th.
Ask your junior DPDF. Let me first catch hold of the finance. You have already filed your affidavit. You have done all your part. The only problem is the finance. Finance is creating the problem. I have passed a long order. Then also they have not filed the affidavit. I think
it is filed. The
this
last
calls
page is
for a
filed.
personal appearance for them. But today I have been in a good mood.
No, it has been filed, my lord. It has been filed. Last week it has been filed.
You filed the
Yes,
affidavit?
this is the subsequent development, madam, regarding last. week.
No more. Yes, Mr. Nair.
It's permitted to make
Well.
a delay, my lord. Item number 12, my lord.
Ah.
My lord, instead of next week, my lord, could it be the week thereafter, my lord? I have
What
some
is the
personal-
matter?
Item number 12, my lord, it is about the Registrar of Industrial Tribunal, the extension of Shetty Commission's recommended pay scheme.
Oh, yes, yes.
Next week, I have some difficulty, my lord.
Okay. You want after vacation?
After vacation also, my lord, no problem, but
Item number 12, list on 24th of July 2000,
24th also, I have
Okay.
submitted.
31st of July.
Mine. Deeply obliged.